Please rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, keep your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have oral arguments for today, April 24. Please, there are over 7.5 hours of argument time requested. Obviously, we cannot exceed to those requests. Please only request the time that you actually need in order to get out the salient points of your arguments. Please be assured that we have read your papers. We are fully familiar with your arguments. People v. Lantiqua Gibbs. I'm sorry? Yeah. 5 and 2 and 5. Wilson v. AC 320 Hotel. Five, 2, 4, 4. Matter of Olga. Is there a respondent? Did you still wish to argue? 3 minutes. Alchnava versus 207 dash 217 West 110.
Matthew Brett for the appellants, requesting 5 and 2.
525. McCormick v. Depersia. 525. Honeywell Partners v. Deloitte Transactions.
Good afternoon, Your Honor. Appellant, Deloitte, 7 and 2, please.
Good afternoon, Susan Muller on behalf of the Appellate. 5 minutes.
625. Nunez v. Global Launch. There's no respondent. Did you still wish to argue?
No, I'll submit.
Thank you. The matter is submitted. Welcome v. BUFNY 2 Associates. Five, 2, 5, 2, 6. People v. Terrell Sumter. That matter is submitted. Rabbaza, I apologize, v. 165 E66. 525. Victor v. Casovich.
Your Honor, for appellant Manhattan Place condominium, 5 and 2, please.
525. Welliver v. TC, the Colorado.
Jerry Christopherotis for respondent appellant Hercules Corporation, 5 and 2.
6 and 2, 5 and 2, 5 and 2. Macaroni v. NY Convention Center.
Respondent, Hussein Biden, Systems Industry Inc., 5 minutes.
I don't know. I thought you were. I didn't know that there was respondent, but we had this last week. The attorney didn't know who he represented. It was an excellent argument, though. Just didn't know who he represented. So who do you think you represent?
Oh, I represent the respondent.
So we have 2 respondents and no appellant.
I'll take 3 minutes. of your time.
You don't have to. I mean, it's not a competition. 3 and 3. 3 and 3. Beast Investments versus Celebrity Virtual. Where is he from? Where are you from? And how much time are you requesting? 5 and 2 and 5. Justice Gesmer is recused on that matter. People v. Luis Pena. That matter is submitted. Stabile v. Dragonati Brothers.
Good afternoon, Daniel Smith for appellants. I request 5 and 2, please.
5 and 2 and 4. And so those are going to be called together, the 2 appeals. So did you wish additional time, or is that fine? They're 2. The second one is submitted. Okay, so the second one is submitted, and the first one, 5 and 2 and 4. Thank you. First matter for argument is People v. Lantigua Gibbs. Whenever you're ready.
Good afternoon, Your Honors, and may it please the Court. Anaga Sundarajan for the appellants, the Office of Mental Health. Supreme Court abused its discretion.
So I was really taken by your argument, and how could you possibly argue that the statement in the order of commitment, which states forthwith, that term, forthwith, last paragraph, the New York City Department of Corrections shall forthwith deliver the above-named defendant. How could you state that that's equivocal, or somehow we wouldn't know what forthwith means?
Certainly, Your Honor. So to be clear, our argument is that a contempt order is places a very specific burden on the party seeking contempt, and it incorporates a clear statement rule.
And forthwith is not a clear statement?
It is not adequately clear.
So what should the judge have stated in order to confer the wish or that the defendant be sent to a psychiatric facility immediately?
Certainly, Your Honor. So the judge could have done a few different things here. The first is the judge could have included a deadline within her order itself, saying—
And if that would have happened, you wouldn't have been able to meet that anyway, right?
No, Your
Because it
Honor.
still took you, how many days? It took you like 3 or 4 days? How many days?
6 months.
6 months. 6 months, I'm sorry, 6 months.
So forthwith means 6 months?
No, Your Honor. The
What
point—
does it mean to you?
So we agree with the appellant that forthwith does contemplate and imply a level of immediacy.
Doesn't it order you to do that with some immediacy, not just imply it?
No, Your Honor, the term in the order does not satisfy the clear statement standard for contempt. Now,
What happened if the judge had told you to do it within a month? What would have happened here?
of course, OMH would have endeavored and done its best to make sure that it met that
Okay,
order.
so again,
had that-
forthwith seems to convey some type of immediacy, even if you disagree as to the immediate immediacy. 6 months?
So, Your Honor, a couple responses to that. The first is, with respect to Your Honor's original question, the other things that the judge could have done is amended the order to direct a faster transfer. Additionally, as we explain in our brief, the issue here is that OMH is facing very severe resource
Yes,
constraints.
so
It
did
could
you
not-
at any time go to the court and say, look, we're facing these issues, we have a shortage of facilities, we have a shortage of beds for females. Did you at any point do that?
We did that in response to the order to show cause, Your Honor, and additionally—
And that was 6 months later?
To be clear, what happened here is before the return date on the order to show cause, Ms. Gibbs had already been transferred because she was transferred as soon as a female bed became
But again, we're
available.
talking about 6 months, right?
Yes, Your Honor.
So during that 6-month period of time, prior to the order to show cause, did you at any point go to the court and say, look, we're facing these issues, we don't have beds for females, and so therefore we cannot comply with your order, and so therefore we need additional time or anything of that nature?
No, Your Honor, but there's not a clear procedural mechanism in a criminal case for OMH to do that.
And counsel, in fact, the shortage of beds was well known to your organization well before this case, right?
Yes, Your Honor, and
For about 2 years leading up, you knew that you were running out of space.
and OMH had done several things to increase its capacity. As we cite in our brief,
What did you actually do to increase capacity? Not the plans that you cited, but what was actually done?
so OMH had opened the additional space at Central Manhattan. Additionally, OMH has been lobbying the legislature, and the legislature is responding. So there is construction underway at Mid-Hudson for an additional facility. The governor's current proposed budget also includes funding and allocation for an additional construction.
So while all of those things are happening, what happens to individuals who are waiting to be placed to get treatment that they need?
And they're waiting at Rikers Island.
Yes, Your Honor, they are. And with respect to those individuals, respectfully, there's nothing more that OMH can do. OMH places them on, OMH designates them to a particular facility. Its current practice is to designate them to all facilities in the state that are appropriate for that individual. In this context, it is a secure facility with a female ward. It is constantly monitoring the situation, so if it can move people around or move.
OMH has a statutory obligation to review what demands there are for its services and address them proactively, correct?
It has, yes, Your Honor, and it has done so and met that statutory obligation here. And again,
I'm curious as how you can say that. At the time that the defendant was designated to Mid-Hudson, apparently the record shows that there were 61 individuals, I'm assuming females, pending admission in front of her. So, how is it that you recognized what the issue was and you attempted to remedy that situation? She's on a list, she's 62.
because
And there's no argument that she was not in need of psychiatric treatment.
That's correct, Your Honor. OMH did everything in its power. OMH, as a subdivision of the state, obviously cannot compel the legislature to allocate additional funds. It also cannot oversee or require Rikers or the city to take additional steps.
But you have an affirmative statutory obligation to assess what your needs are and to proactively plan for those needs, correct?
Yes, Your Honor, but contempt is a very specific remedy here. And here, contempt is inappropriate in these circumstances, as the Court of Appeals decision in Eldedin and others that we cite in our brief make clear. This, of course, does
You have time on rebuttal. Thank you.
Thank you.
Yes.
May it please the court. Jennifer Hose of the Legal Aid Society on behalf of Ms. Latika Gibbs. This court should affirm the Supreme Court's decision holding the Office of Mental Health in civil contempt for failing to admit Ms. Gibbs to an appropriate psychiatric facility for restoration services for over
Justifies the $1,000 penalty.
Your Honor, at the time when Judge Neubauer issued her decision holding them in contempt, she was well aware of the fact that Ms. Gibbs had been subjected to an additional 180 days of incarceration based on the failures and inaction of the Office of Mental Health. She had, within her power, the ability to order a monetary fine to compensate Ms. Gibbs for that injury.
How do you determine the amount of the fine?
There have been different courts who have determined damages without there actually being proof of actual damages based on prolonged incarceration. And this
Also, did you provide any evidence to quantify the losses or possible injuries that she suffered?
the evidence that was provided to the court was the numerical amount of time in which Ms. Gibbs was suffering without having this court-ordered mental health treatment while she was on Rikers Island, which is, of course, one of the worst places for somebody like Ms. Gibbs who is suffering from mental illness based on the well-documented.
Right, but the question is, was there anything provided by you as to how that 180 days while she's awaiting admission to a psychiatric facility, how that translates to $1,000?
There was no evidence that was provided based on the actual damages. However, courts in many cases that I've cited in my brief are able to render a decision as to compensation without proof of actual damages. Here, the court was well aware of how long Ms. Gibbs had suffered. They ordered a modest fine based on the injury suffered to Ms. Gibbs. Ms. Gibbs's case was the only one that was before the court. It was based solely on Ms. Gibbs and what the court felt was appropriate. And the court had ample evidence in its record to compensate Ms. Gibbs for the injury that she did suffer.
Are there other cases that are comparable in terms of duration where no actual evidence was provided as to that individual and courts awarded a contempt fine in this amount?
The cases that I do cite in my brief are not in the context of a contempt finding. However, they are federal cases in which someone was subjected to only a few days of incarceration, and they were damages up to $10,000.
Right, but there was a calculation as to what the damage was per day in those cases.
But in those cases, there was no proof of actual damage that was submitted to the court. Here, this was a modest fine that Judge Neubauer issued based on the injury that Ms. Gibbs did suffer, which was very clear in this case. Judge Neubauer found that not only was she prejudiced, but her rights were violated, and that her case was ceased. She had no right, based on the mechanisms in CPL 730, she had no ability to seek any sort of due process. She couldn't seek release.
Right, but again, the problem is, or the issue is, how do you attach a monetary value to that? I mean, the statute talks about $250 plus whatever other showing there is, and so therefore it would seem to be the baseline would be $250, and then after that you would have to make some showing as to how the 180 days, how you calculate some type of monetary damage for those 180 days.
Well, she did know that she was incarcerated for 180 days and $250 being the baseline. And so $1,000 does seem to be in line with the prejudice that Ms. Gibbs did suffer, and that and it was a modest fine in comparison to other cases in which somebody is subjected to prolonged incarceration.
So in terms of the contempt finding, what was OMH supposed to have done during that 6-month period of time? I mean, recognizing the lack of facilities, for females, lack of resources, et cetera, what should they have done? Or what could they have done?
The record the Judge Neubauer based her decision on the record that was before the court, where OMH failed to really show any sort of evidence that they had responded to this trend that their own data had shown had been happening since 2015. Rather, they simply, through their affidavit that was submitted from BITS Director Matthew Schatzel, it essentially shows that they had just accepted that people were going to have to suffer these significant waits and that there was going to be a wait list because they always operate at capacity. This is an issue that they had been aware of since 2015, and as Judge Neubauer said, they were aware of it based on their own meticulous record keeping, yet it did not command their full attention in a way in which it should have.
Well, their argument is that, go ahead.
I was curious whether, certainly there are some government agencies like homeless shelters that end up renting parts of a hotel to deal with overflow issues. Does OMH ever do that?
OMH consistently feels as though every person who has an order of commitment must be at a secure facility, and so they operate the secure facilities that are currently at capacity. Judge Neubauer did explore with the Office of Mental Health during her arguments whether they could repurpose certain facilities to accommodate the need, and it was clear based on the answers from counsel that that was not something that they had explored. And so the record in this case was really about the fact that the court found that forthwith was a clear and unequivocal mandate. There was a lack of any sort of evidence or submissions by the Office of Mental Health to show any sort of efforts that they had taken to make it so this wasn't a problem of this making that would lead to Ms. Gibbs and others similarly situated having to wait for close to 6 months at Rikers Island before they had that treatment. The question before the court was a narrow scope of whether contempt was appropriate, and there was ample support in the record to find that it was. And so I ask that Your Honors affirm the decision.
Thank you.
3 quick points, Your Honor. The first with respect to Your Honor's question about alternatives for OMH. Because Ms. Gibbs was charged with a violent felony, she could not be placed anywhere other than a secure facility without consent or approval from the district attorney. And so
was that sought?
No, Your Honor, for a couple reasons. The first is, with respect to OMH, that consent needs to be provided before the order is entered under the procedure laid out in 730.
Was the court ever made aware of this? Was the court or any court ever made aware of the fact of the issues that OMH has in terms of these facilities?
I'm not sure, Your Honor. However, it is a well-documented issue. Like I said, the legislature and the governor have been...
And the proposals that you have, that you state that OMH, was endeavoring to make these changes, et cetera, they seem to be long-term, right? And you need legislative approval, you need construction. What about in the short term? Was there anything proposed or done in the short term? My colleague mentioned repurposing, anything of that nature?
So with respect to secure facilities, repurposing is itself a long-term project because under Section 33020...
Faster than building from scratch, though.
It is, Your Honor, and that's what was done with Central New York Psychiatric. OMH is considering others. However, if it repurposes an existing hospital ward, that of course removes...
I'm assuming there's also a wait list for males?
Yes. This is a wait list across the board because secure facilities have to meet certain statutory requirements under both state and federal law.
I thought that I saw on the record that there was a wait list for females, and at some point in time, she was on a wait list for females specifically.
She was specifically on a wait list for females because these are gender segregated wards.
Right.
There is a wait list for males for the wards.
So is there so you could not repurpose a male ward for females if you have more females on a wait list than males?
Not without moving the men in that ward out of it and finding another placement for them, Your Honor. That is the problem here. And OMH, of course, can't control how quickly...
I'll give you a minute to address the issue as to the fine.
Certainly, Your Honor. So as we explained in our brief, civil contempt has two purposes, and neither of them was satisfied by the order here. As we noted, she had already been transferred before the return date for the order to show cause, so there's no need to compel compliance. With respect to the fine, on the face of the order, the trial court was not endeavoring or contemplating compensating Ms. Gibbs for anything. Rather, the trial court says very explicitly that the fine is meant to deter and to punish. That is inappropriate for civil contempt, and at the very least, this court should remand for the court to reconsider that, especially because the court made an explicit finding in its order that there was no willfulness necessary to support a finding of criminal contempt or a punitive sanction.
Thank you.
The court has
Thank
no
you
further
both.
questions. Thank you.
Wilson v. AC 320 Hotel. Yes, you may proceed.
Good afternoon. My name is Cole Munson, and I represent the appellants. We, the appellants, are appealing from the branches of the lower court's order, which granted partial summary judgment in favor of the plaintiff as to the Labor Law 240 claim, as well as the branch of the lower court's order, which granted summary judgment dismissal of appellant's third-party claims as against Rockledge Scaffold. Starting with the Labor Law 240 claim, the lower court erred in that it should have properly found there an issue of fact as to whether the scaffold involved in this accident constituted a adequate safety device.
Well, there was a gap between the scaffold and the facade of the building, wasn't there?
There was, Your Honor, and as the court held in the context of the 241-6 claims...
So isn't that a 241 violation?
Well, there would be a 240 violation if the scaffold was inadequate. If the gap in the scaffold was integral to the work...
It was inadequate, because if it was adequate, you wouldn't be putting in styrofoam to fill up the gap.
And again, hasn't been decided what the styrofoam was being used. I'd say there's a question of fact whether the styrofoam on which plaintiff stepped on when he fell was just part of the materials being used.
What's the theory that the gap complies with 241?
Well, if the gap was integral to the work...
Right, so how was it integral to the work?
Well, as the lower court held in the 241-6 context, it was integral to the work being performed by plaintiff because materials were being passed from workers on the ground floor up to plaintiff on the sidewalk shed scaffold. And additional safeguards, there's an issue of fact as to whether additional safeguards such as guardrails around the gap would have rendered it, would have been contrary to
How
the
would
work.
the-
Gap, didn't you need anchors to tie you up to?
Again, I would say that would be an additional issue as if the scaffold were deemed to be inadequate.
Well, how would the anchors, though, interfere with the work that was being done?
It wouldn't necessarily interfere with the
Why
work that would
isn't-
be
why
done.
was- Why isn't that an appropriate safety mechanism that was not available to this worker?
It's an additional safety mechanism,
No, it's
which
an
was not,
only safety mechanism.
the safety mechanism was the scaffold. And if
How
the-
is that a safety mechanism if he falls through the styrofoam that's not really meant to hold up a person or any real weight?
Well, the scaffold is a safety device enumerated under Labor Law 240.
But
It
then
would
there's a
be-
gap between that, which admittedly, and the facade. So how, isn't that a problem in terms of a safety mechanism?
It would be if the gap were deemed not to be an integral to the work. If it's integral to the work,
If
then
it's
it wouldn't
integral
render
to
the scaffold.
work, didn't you need anchors to tie you off of so that you don't fall through the gap?
Again, I would say that that would be an additional safety device which wouldn't necessarily be required, and the gap itself does not render
How
it
could it not be
inadequate.
required if you have this gap which permits someone to fall through?
The gap, again, is integral to the work, and if it's integral to the work,
You
the scaffold is not.
You're saying it's integral to the
You're
work,
just going in
okay.
a
It's,
circle.
it's the law of the case.
Let's assume it's integral to the work, okay?
the
So
law
you
of the
can stop
case.
saying it. How, I'm not understanding, however, how the scaffolding protects someone from falling through the gap. The scaffolding it stops, and then you have the gap, and then you have the other building. So how is the scaffolding preventing someone from falling through that gap?
The scaffold doesn't have to protect someone from falling through that gap because it's. the
So
purpose of
what
it-
protects someone from falling through the gap?
I'll just cite to the Salazar case where we dealt with, the Court of Appeals dealt with a similar case where there was a trench and no additional safety protection was required for this trench because it was integral to the work.
But the
So-
trench is something that one can see and avoid, whereas the gap here is a significant gap that someone could fall through and end up significantly
only a
hurt.
portion-
I don't see how that's analogous
If we're
to
getting
this
to
at
this,
all.
if we're getting to the styrofoam issue, then that would only covered a portion of the gap, and that would then lead to a proximate cause argument because there's sufficient evidence in the record that plaintiff is the one who placed
I do not understand. So I thought that was an interesting argument, made no sense to me personally. So you're stating that the plaintiff comes to work carrying a pink styrofoam, right? A portion of pink styrofoam, right? And then the plaintiff places it over this gap, partially obscuring the gap, but then the plaintiff steps on the styrofoam knowing that it's not going to sustain his weight, but he still steps on this styrofoam that he has brought from home or from wherever to put over the gap?
Well, actually, I say that the styrofoam would have been passed up to him from the worker on the ground.
Sorry?
The styrofoam would have been passed up to him
Okay,
from the
so we
worker on
have
the
a
ground.
co-conspirator now who is helping him with the styrofoam, placing the but then the plaintiff but the plaintiff for some reason believes that he's going to step on the styrofoam and it's going to sustain his weight?
Again, there's no claim here that he did it intentionally. It's
So why would he
material that would have been.
unintentionally place the styrofoam partially over the gap?
People make mistakes and accidents all the time. I don't know why he would do
Should
that.
there
or he
not
may
be
have
some
done it
semblance
negligently.
of some
But that would be-
semblance of rationality or some semblance of sense, right? Semblance of sense as to why anyone would do such a thing?
I mean, there's many contexts where you would hope that someone uses some sort of sense, but
Like this argument. You have time on rebuttal.
Good afternoon. Lori Parkman for Plaintiff Respondent. I think your honors have a good handle on this case. Their argument that it was integral to the work is completely belied by the evidence and the case.
Well, I mean, there's some argument, right, that the aluminum, I think it was aluminum, other things had to be passed through, right, through the gap.
They argue that the passing through plaintiff was not engaged in that work. And the Court of Appeals case in Bezderek recently in 2024 made clear, first of all, that it has to be inherent to the work plaintiff is performing. Plaintiff didn't even know that there was a gap. He was not engaged in passing
It
materials.
doesn't really matter whether it was inherent to the work, because if it was inherent to the work, you needed an alternative safety device, and there's no indication that that alternative safety device was provided here. So it's not really a determinative issue.
Exactly, Your Honor. That was my point too, is that Ms. Derrick made clear that defendants, even if it's inherent to the task, defendants have the obligation of showing that the dangerous condition couldn't have been made safer with preventative measures. Here, there was no railing to stop from the gap. He couldn't get tied off, and the gap was hidden by styrofoam, which defendants' own witnesses testified they didn't know why it was there, and it was insufficient to hold. Clearly, even if the gap itself was inherent to the work, defendants did not even try to show that all these other preventative measures could not have been used without imperiling the work. It was not integral to not have a railing and to not have him tied off and to have this piece of styrofoam.
Is there any way the presence of anchors or a railing would have interfered with the use of with the ability to pass things up from the ground level to that scaffold?
No, we submit we can't see a reason, and it was their burden to show that they could not have used these safety measures because they would have interfered with the purpose of the gap. They didn't even try to make that showing. So clearly, the court, we submit the court was correct to reject that defense and to grant plaintiff summary judgment on the 240 claim. Just quickly, their only other argument on this branch was proximate cause. The argument that plaintiff placed the styrofoam is pure speculation. He testified he didn't even know the gap was there. The styrofoam was not the color used by his employer. And their argument that he should have seen because edges, the photographs, specifically at page 647 of the record, show clearly that the gap was hidden by this styrofoam in the place where he stood.
Even if he could have seen it and he wasn't looking where he was going, that would be comparative negligence.
Exactly. It's what they call a disguised claim of comparative negligence because the statutory violation is clear, and it's clearly a proximate cause that there was no railing and the styrofoam was hiding the gap and he couldn't get tied off. Those are clearly proximate causes of the accident. And if the statutory violation is a proximate cause, conceptually, the plaintiff cannot be the sole proximate cause.
Thank you.
Thank you.
Afternoon, Your Honors. May it please the court, Valerie Prezimenter for Respondent Rockledge Scaffold Corp. Respectfully, the lower court got it right with respect to
So Rockledge was not on the site at the time that the incident occurred, right?
No, they were on
They
site
installed the
You installed
scaffold
it?
and they left.
Yes, and they were installing it specifically to the specifications required by Flintlock and their working platform plan.
But you left the gap, didn't you?
The gap was there intentionally.
You were asked to leave the gap, but wouldn't a proper installation of that scaffold, since you've been asked to leave a gap, have included placing anchors so that someone doesn't fall through that gap?
Placement of anchors is not something that's the responsibility of Rockledge. It's the responsibility.
You're putting up the scaffold. The anchors would have been part of the scaffold, wouldn't they?
No, the working plan did not call for any anchors. They have
Who
no.
created the working plan?
The working plan was prepared by engineers hired by Flintlock, and we installed it pursuant to that plan. They specifically needed that gap in between the building and the platform in order to pass those materials up and to pass the materials, the aluminum panels up.
But so hasn't Rockledge put up an inherently dangerous scaffold?
The scaffold itself is not inherently dangerous.
You've left the gap?
Under the circumstances,
Under
with the gap.
circumstances either, because it's the owner and employer's duties to provide safety measures for the workers to work there safely, knowing that there's the gap that they specifically requested. They needed that gap. Without it, they couldn't do the work to begin with.
But you knew the gap was there, and you knew that the specifications, based upon the specifications, that the gap was going to be there. So you're putting up the scaffolding. So should you not also be cognizant and therefore perhaps provide anchors or say something as to why anchors would be necessary, given that gap?
There were engineers, there was site safety personnel. The GC specifically requested this to be built as is with that gap. What other responsibility does the provider of the equipment have to the workers there? It's our position that they did all that was required.
I think you're sort of more than a provider of equipment. I mean, you're putting up a scaffold to provide protection against falls, and the scaffold that you've put up clearly leaves the fall danger present.
Well, there was specifically part of the contract required Flintlock to fill the distance between the edge of the building and the platform. And that is what they were doing. When our foreman left the site, Flintlock's Superintendent Smith said he will partially cover that gap because they were aware of it. They specifically requested it, even at the installation. Everything else is the responsibilities and duties of the general contractor who's there on site. He knows when the workers are doing, what kind of work they're doing. How can it be the responsibility of someone who's just putting up the scaffold as they specifically required and needed for them, and their contract did not call for any safety measures such as those anchors.
I think the question is whether or not you have any obligation or any liability where you put up what could be deemed an inherently inadequate scaffolding.
In this case, this was not an inherently inadequate scaffold. The lower court actually specifically said that there was no evidence of negligence on the part of Rockledge in its installation of this platform. And the contract specifically required the Flintlock to be responsible for monitoring that gap and filling that distance. In terms of the contract, again, there's no evidence of negligence or that this arose out of the acts of Rockledge, because the proximate cause of the accident was the placement of this, I'm sorry, one second, the placement of the styrofoam over the gap. It was.
Thank you.
Thank you.
For the rebuttal, I'll just simply discuss the contractual indemnification issue as against Rockledge, unless we want to discuss other issues. As in that regard, the contract, specifically the indemnification clause, has an arising out of trigger, and the explicit language of that indemnification clause is that it applies to violations of, or alleged violations of Labor Law 240. A arising out of trigger simply requires some causal connection between the accident and the contracted for work. Plaintiff here fell from a scaffold that we, the appellants, contracted with Rockledge to construct. That alone is sufficient to satisfy the causal connection requirement for rising out of. Now, if we want to take that a step further and take it a more stringent standard, which again I do not believe applies, but even if you were to look at it in that context, the accident, if there's a deficiency and there was leading to a violation, it'd be potentially with the gap, as we discussed earlier, which certainly would establish a causal connection between the accident and the contracted for work. And as this court held in the 2017 decision of Jagenati versus Tishman, the lack of anchors and tie-off points on a scaffold raises a question of fact whether the scaffold was inadequate. So at the very least, there are issues of fact as on this issue, and the court erred in dismissing the contractual indemnification claim.
I want to be clear, you asked for the gap, correct?
We did ask for the gap, yes.
Okay.
But again, I want to be clear, this is not a negligence question. This is just simply an arising out of. So regardless, I see that the court made the argument that they weren't negligent. That's not relevant to the contractual indemnification issue.
Thank you.
Thank you.
Matter of Olga P.
May I proceed?
Yes, please.
May it please the court, Nancy Green for the appellant Fabio G. This appeal challenges the family court's erroneous finding that the father committed sexual abuse in the second degree. Respectfully, the record does not support that
Isn't that a
conclusion.
finding of fact and based on the credibility of the witnesses who were before the court, who was in the best position to consider those questions?
I think it's more a question of a matter of law, that the court applied the wrong standard of law. It was the mother's burden to prove by a fair preponderance of the evidence that the father had engaged in an activity for the purpose of sexual gratification, which is required by statute. That was not proven here, and that was not considered.
Sexual gratification is usually, it's rare for someone to stand up and say, I did this for the purpose of sexual gratification. So the court has to draw inferences from the facts which are in front of it. Why should we reject this court's findings, the inferences that the court drew from its evaluation of the witnesses who were before it?
There are several different ways the photographs could have been looked at, but this appellate...
Well, it was not only the photographs, right? There were other things as well. It was the photographs. It was the father's acknowledgement as to kissing his son on the lips. There were statements in the record that he made to the son. So, I mean, it wasn't only the photographs, which the photographs were only one piece.
Well, this court, in matter of AG, specifically rejected those very similar acts made by the father, such as, which were even worse, I think, bathing nude with the child, describing the child as sexy in front of the child, sleeping nude together, touching tongues while kissing. And this court did not find that to rise to the level of sexual gratification. While these things happened, it didn't show the intent of sexual gratification.
Again, the judge was in a better position to assess credibility of the witnesses here once they were shown the exhibits of the picture. So why should we disturb that?
I think the court needs to look at the entire context in the familial relationship, and the lower court did not do that. The lower court applied a standard that did not take into account that this was a father and a child, did not take into account the cultural norms in the Italian culture.
What are the cultural norms that you're speaking about?
This is an Italian family where the father was raised with a lot of touching and hugging and kissing. And
Touching of a child's genitals?
there is no proof that the genitals
The photographs are clear, where, I mean, the photographs clearly show the father touching the child's genitals.
It's hard to tell from most of the pictures where the father's hand is placed and where
Between the legs of the child.
Of a small child.
Of a small child, while the child is on the father's lap.
I don't think the child was on the father's lap. And
He's next to the father on the sofa.
He's next to the father on the sofa. I have the photographs here. He's next to the father. He's actually lying on, I'm sorry, yeah. He's next to the father on the sofa. And the father's hands are between the child's.
The father even admitted in one of the photos that he was, in fact, touching the...
Yes, there was one photo where he did state that he was moving the child's hand away because the child was playing with himself. And
there's another one with the child's hands on, the father's hands on the buttocks. Now, I recognize that in your papers you talk about, some type of Italian tradition of parents or fathers kissing their child on the lips. Okay. But the photographs and other statements made by the father seem to be sufficient to sustain sexual gratification.
Not within the familial context.
I'm not understanding.
I'm lost.
Are you essentially saying that the court didn't take into account cultural Italian norms of affection between father and son? And had they taken that in, that would have given the court a different view of these photographs?
I think it would have given a different view, not only the cultural norms, but also the parent-child relationship.
So you're stating that in a familiar relationship, in a parent-child relationship, a father may place his hands on the child's genitals, place his hands on the child's buttocks, etc. That's fine in a familiar relationship?
Well, according to matter of AG, yes, that is.
I don't think that's what it says. Well, I mean, again, I have it here, but I don't think that's what it says. Yes.
I was just going to ask if, I don't recall the father having testified that that was cultural norms that he grew up with. He testified that there may have been different standards about touching, but I don't believe there was testimony that he said that fathers typically touch their sons' genitals.
He said that in the culture, in his culture, or as he was growing up, it was fine for a father to kiss a child on the lips, and it was fine for the father to say to the child, "I love you, te amore," or something, and to ask repeatedly whether or not the child loved him. That's what he said. I didn't see anything about the touching of genitals.
I think the court still needs to look at the touching of the genital area above the clothing within the context of the familial relationship, which the lower court did not do.
So you're saying there's a familia exception?
Correct.
Yeah.
Where,
Thank you.
here or in Italy?
Here.
Here.
Thank you.
Thank you.
Alchnava v. 207-217, West 110th or 110. Yes, please.
Thank you. May it please the court, my name is Matthew Brett. I'm here on behalf of the current owners and the appellants in this case. The appellants who are the current owners and the management, I want to correct that, who are appealing the supplemental order of Justice Lyle Frank, who in turn incorporated by reference and adopted the findings of Justice Edmeade from 2021.
Counsel, I have a question.
Sure.
So in Justice Edmeade's order, she directed both parties to submit various documents, I believe within 60 days. In the record, I found some submissions from both sides, but neither your submissions or the submissions on behalf of the tenants seemed to me to correspond to what Justice Edmeade had asked for, which were very specifically about numbers. So did anybody make any submissions consistent with what Justice Edmeade had asked for?
We did. We believe that the submissions were ultimately made. I don't think they were made in time.
Okay. Are they in the record before us?
No, they're not.
Okay, so how are we supposed to evaluate whether or not you did what Justice Edmeade requested when you didn't put any of that in the otherwise voluminous record that you gave us?
Because the issue here, Your Honor, is that Justice Edmeade's ruling as to having to do these submissions was contrary or is contrary to the existing law, because ultimately she found, she didn't grant summary judgment, she held it in abeyance, saying that we have to have submissions to determine what the actual, before liability can attach. So, but what she based her decision on, which is what we're appealing today, and which has been subsequently pretty solidly departed from in this department as well as now in the second department, is the fact that she was basing pre-Roberts deregulations on largely the fact that there wasn't registration until much later. So the issue for submissions was really a subsequent issue, really for the issue of damages.
So you didn't think you were bound by her order directing you to produce those documents?
No, we believe that we were subject to that order, and we believe that we complied with that order. But what we're appealing here today is the order itself, which says that there can be a fraudulent scheme to deregulate when you have a situation where the registrations weren't done, and that's clearly not the law here in pre-Roberts cases. It's consistently across the board. The Appellate Division has said that is the case.
So Justice Edmeade found there was a fraudulent scheme as to both you and your predecessor owner under the then standard. In what way is the standard that she used no longer appropriate? What case law do you rely on to say that the standard she used is wrong?
Sure. We list a bunch of cases that deal with this specific issue. Casey against White House, which is the Court of Appeals decision, the Tribbs decision, which was this court's decision, which specifically said the failure to register is not a pre-Roberts a fraudulent scheme to deregulate.
What criteria besides that would have been relevant under the standard that you're suggesting?
I'm sorry, I missed that.
What criteria should she have considered?
Well, she shouldn't have considered this a fraudulent scheme to deregulate, because in Regina, as well as all the other cases, this conduct is not a fraudulent scheme to deregulate. It is.
But the question wasn't only the failure to register, it was also, in many cases, a decade of no registrations. There were inexplicable jumps in the rent regulation. So there was more than just the failure to register, wasn't there?
Not really, Your Honor. And consistent with cases like Tribs, where in fact there wasn't a registration until 10 months after the 2016 initiative. But I want to point out something that's really critical in this factor here, is that when my client became the owner of the property, within months, they registered the property properly. So the predecessor...
We don't know if it was proper. We know that they registered. We don't know if the rent amount was proper.
Well, it turns out that the rent amount that they had to use was consistent with what the Regina formula was. So I do believe that it was proper.
How do we know what the Regina formula was if we don't have the data in front of us to consider what the rents were paid by these tenants?
Because the Regina formula does not require that data. The Regina formula says that when there was an unlawful deregulation pre-Roberts, you look at what the rent is on the base date, which was August 16, 2012. That rent is legal rent.
But the court also found that there was sufficient indicia of fraud to allow it to look back beyond the 4 years.
Absolutely.
Are you rejecting that?
We are rejecting that because the basis of that sufficient indicia of fraud is a failure to register. That's what Justice
That's not how I read the decision. I read the decision to include the large gaps in registration, the inexplicable jumps in the rent. Are you saying those are things we shouldn't have been considered?
They should not have been considered because the decisions that you have issued in this court has specifically said that jumps in the rent as well as failure to register do not constitute a fraudulent scheme to deregulate in pre-Roberts cases. That's what
Thank you.
that's
You
what
have
case
time on rebuttal.
Thank you.
Thank you. Roger Sacker, Newman Ferrara LLP. May it please the court.
Counsel, could you pick up where your friend just left off? Is that what we have stated in our previous cases?
During the spring and summer of 2023, there was a series of decisions that employed a common law fraud standard. Those decisions, in some cases, found that pre-Roberts deregulations with failures to register could amount to common law fraud if scienter is proven at trial. Others said no. And in fact, there were two decisions that were issued 2 days apart that disagreed on that. Subsequent to that, we have learned that common law fraud is not the case. My adversary cited a case called Arras. Justice Casimir, you wrote the dissent. That case has now been overturned, and Burroughs specifically said it is no longer good law. We also have the clarifying legislation that says it's not common law fraud standard. We look at the totality of the circumstances. And if you look at the totality of the circumstances here, if you don't have fraud in this case, you don't have it anywhere. You have a landlord that deliberately withheld a due diligence report. This court said we're going to presume willfulness. They were unable to support any rent, even aside from J51. They failed to register after Gersten. The buyer defendants were informed, hey, they don't have the J51 records. They knew that they threw out the documents. The seller defendants were told by Justice Scarpula, register. I don't ever want to be the one defying Justice Scarpula. You have to register. Do what she says. I just don't see how you don't have it here.
I'm glad you mentioned Burroughs because isn't Burroughs like on all fours with this particular case?
The difference between this particular case and Burroughs is in Burroughs there were registrations. They were just fraudulent. The landlord utilized a preferential rent as the first rent. But yes, it's saying, look, a landlord who breaks the law, violates the law, that can give rise to a fraudulent scheme to deregulate. The difference would be, of course, that was a motion to dismiss. This is a motion for summary judgment.
But the reasoning.
The reasoning and the logic, yes. I do want to touch on your question about the calculations. Mr. Brett came into the case after all of that happened. So we had, after the decision was rendered, we had a series of meetings with Justice Ed Mead and her clerk regarding those calculations. She ended up putting...
Any of that in the record in front of us?
Oh, not in this record, no.
Counsel, if it's not in the record, how can you ask us to consider it?
I'm not asking you to consider. I was just explaining why it isn't in the record. Those calculations have now been submitted to the court. We have a meeting, a pretrial conference next week. So we finally got there. Justice Ed Mead left the bench, and there was a long delay in trying to get those decision on that. If there's no further...
I'm curious. The Second Department's decision in Gomes came down, I believe, after you submitted your brief in this case.
That's correct, Your Honor.
What do you think are the implications of Gomes if we were to follow it, particularly as how it dealt with whether there was a fraudulent scheme.
Well, Gomes said, look, one of the things we look at, first we look at owner knowledge. And we know what the owner knew here, right? They were told by Justice Scarpullo, you have to register. They testified under oath that they knew, the seller defendants. In addition, it says, look at owner sophistication. We're not going to say, even willful ignorance can rise to knowledge if you look at owner sophistication. We put forward owner sophistication. These guys owned properties on Central Park North. One's a Yale graduate, another's a lawyer for one of the largest law firms in the city that deals with real estate matters. These are highly sophisticated parties that knew exactly what they were doing and negotiated a purchase price offset by their J51 risk. Thank you.
Thank you.
If I may just touch upon Gomes, because I think Gomes is actually directly on point. If this court were to follow Gomes, I think the finding would be exactly that there was not a fraudulent scheme to deregulate. Gomes did an analysis of the chapter amendments, very specifically.
Wouldn't
and it
leave
addressed
an-
the
wouldn't
issues,
it
the
leave
same.
an issue of fact?
What's that?
Wouldn't it leave an issue of fact whether it was a scheme to regulate?
It wouldn't be unless there was facts that would rise to that. And in Gomes, in particular, they dealt with the registration issue and facts jumping a gap. They pointed out that the chapter amendments, the original bill that they were amending, which was the 2023 amendment, actually had language in there that said failure to register is consistent with fraud. That was removed from the chapter amendments. If you read the Gomes decision, they do an analysis, and they cite back to all of the First Department cases, Tribbs, Aris, all the other cases that specifically said that a failure to register is not a fraudulent conduct in these situations, especially pre-Roberts. So the chapter amendments actually specifically eliminate a failure to register as a grounds for fraud.
Several of those cases have been argued before the Court of Appeals and have not yet received decisions, right?
I don't believe.
Certainly Aris, I'm not sure.
I think Aris is the only one that I'm aware of that hasn't been argued. I don't know if there's any other ones that are currently being heard by the Court of Appeals. Mr. Sacker would probably know because they're most of his cases. But in particular, the point we want to make here is that the owner acted appropriately, immediately. They did what they were supposed to do. They didn't engage in a fraudulent scheme to deregulate.
Under Gomes, the court said that there was a failure to eliminate tribal issues of fact as to whether, under the totality of the circumstances, the defendant knowingly engaged in a fraudulent scheme to deregulate an apartment unit.
Correct.
As my colleague stated, wouldn't there be an issue of fact?
Well, there could be if there was other allegations that would support a finding of fraudulent scheme to deregulate. But in Gomes, they also specifically said that the failure to register alone or a jump in rent and the failure to register is not constitute grounds for a fraudulent scheme to deregulate, even under the new law.
Thank you.
Thank you.
McCormick v. Depersia. Whenever you're ready.
May it please the court, Tim Norton on behalf of the appellant. While the lower court erred in failing to grant our motion pursuant to Labor Law 240 parentheses 1 and Labor Law 241 parentheses 6, the court got several issues correct below. It correctly determined that a fall into the trench while attempting to enter represents an elevated risk that's protected by Labor Law 240. The court also correctly found that the height differential between the different testimonies here would be irrelevant for the purposes of determining whether this is a labor law related risk. So whether the trench was 2 feet or 8 feet, it's irrelevant for the purposes of finding whether this is an actual labor law case under 240. The third thing that the court got correct was that the plaintiff was not a recalcitrant worker or the sole proximate cause did not raise an issue of fact here.
So what did they get wrong?
Thank you, Your Honor. I was just getting to that. It's particularly the issue of whether or not the ladder, which were safety device to enter the trench was a feasible safety device in
So
this.
your client, the plaintiff testified that he was told to jump, right?
Correct.
And that, I don't know, that he said there was no ladder?
So there's no evidence that a ladder was available. He says specifically that he asked for a ladder and one wasn't provided to him. And as he tried to enter the trench, he fell. And because of the fact that there was no ladder related, this is a falling worker case along the lines of many of the cases cited in our brief. There is no evidence to suggest that this was not a feasible safety device. In fact, the evidence is very clear that not only was it a feasible safety device, but it was necessary safety component for the work to be performed correctly and safely.
So you mentioned the depth of the trench. The defendant's expert's affidavit stated that the trench was only about 2 feet deep.
The defendant's expert affidavit is purely speculative. The 2 feet that comment that he makes is based solely on a pre-construction estimate, which is very unclear if you look at the particular provision.
Was there any examination by that expert of the job site?
I'm sorry, I missed.
Was there any examination of the job site by that expert?
Correct, Your Honor. There's no
none?
examination by the expert.
And when was that rendered? How many years after the?
I believe it was not the. Are you referring to his inspection or
Yes.
the lack of inspection?
Yes. That was about 6 years after.
Right. So it was 6 years after, and clearly this is speculative and not sufficient to raise an issue of fact. I'd also add that he didn't consider the accident report, which further confirmed that the depth was not even 2 feet, but it was 3.5 feet. So this is very clearly. The evidence is overwhelming from all parties here that this was a feasible safety device and a necessary safety device. And in addition to plaintiff's testimony, in addition to our plaintiff's expert testimony suggesting that it was a feasible safety device, as I mentioned, the accident report specifically says in very explicit fashion the contributing cause of this accident was the failure to provide a ladder. So it's very clear, obviously, that this is a not only feasible but necessary safety device. And with respect to with defendant's expert, it's purely speculative, and there's no testimony in the record from anyone suggesting that it wasn't a proper safety device.
So the Supreme Court denied the application. Excuse me, denied granting summary judgment, finding that there was a factual issue as to whether the slab was part of a walkway under excavation, and therefore would have been whether it would have been practical to maintain safety devices around the trench or brace or shore the walkway. What is your response to that?
I believe that the lower court is confusing the cases like Salazar and the other cases with inadvertent falls into the trench and preventing people from falling into the trench while walking alongside. This is a case about access to the trench, which is directly part of the excavation work and a necessary safety component. And I would point to this court's decision in Jenka, which Judge Gessmer, you were part of on the panel, which specifically rejected this kind of just pure speculation that the safety device would not be feasible. And I would point out that the evidence here is even stronger, where you have defendant's own accident report particularly confirming that a ladder was necessary, and that was a contributing factor to the accident. And just briefly, I just would add—
On rebuttal, you will continue.
I'm sorry. Thank you, Your Honor.
Yes.
Good afternoon, Ryan Sweeney for respondents Navasink and Sullivan Land Services.
Counsel, your own accident report indicated that a ladder was necessary to prevent this accident, right?
Well, the accident report refers to several potential causes. It includes that there was no ladder.
Did it refer to the fact of there being no ladder as a cause?
It refers to there being no ladder, but there is an issue of fact on whether a ladder would have prevented this accident, because before a plaintiff even goes to step down where a ladder would be, the concrete slab collapses. So there's no showing, and there's an issue of fact on whether how a ladder would stop the concrete from collapsing.
But doesn't Brian Laurie said that he should have been told to use a ladder?
Mr. Laurie acknowledges that depending on the depth of a trench, a ladder may be required, but there's an issue of fact on how deep the trench was.
What did he testify to? Didn't he testify that someone should have told him to use a ladder?
I think he said that there may be a ladder required to go into a trench, but there's an issue of fact on the depth of the trench. There was testimony from plaintiff that it could have been 1 or 2 feet.
You provide a ladder that accounts for the depth of the trench to ensure that you provide a proper safety device as requested by the plaintiff.
Well, I think there's an issue of fact about the depth of the trench and how a ladder would have prevented the collapse of the concrete. So it's not necessarily that a ladder would have prevented that, but the concrete collapse is what caused plaintiffs to fall into the...
Well, did it collapse because he was walking on it? Did that contribute to its collapse?
Well, it's not clear, but there's no showing of how a ladder would have prevented that as they were working, digging the trench and removing the concrete. It's not clear why or how he stepped on the concrete and how that collapsed falling into the trench.
I'm not understanding. So you're stating that there's no safety device which would have prevented this incident?
Correct.
I don't.
So there's no showing of what safety device would have prevented this accident if he's stepping down into a trench, but before he does that, the concrete that he's on collapses. There's no showing that a ladder would have prevented that accident. And if they're removing that concrete,
Concrete is within the trench, right?
No, it's on the ground adjacent to the trench, and that's being removed as well.
That's not how I read the record. I thought he jumped down into the trench because there was no ladder and landed on this piece of concrete, which then broke and hit him on the leg.
No, what he says is he's going to go down into the trench. He's standing on the walkway, about to go into the trench. The concrete collapses, he falls, and then it follows him and hits his leg.
That's not how I understood.
His testimony is quite clear that he's standing on the trench as he's about to go down. Concrete collapses, he falls into it. And just turning to the McHugh affidavit, McHugh reviewed all the evidence.
Plaintiffs 6 years afterwards.
Well, this accident, this complaint is brought years later, so he reviews
Mr. McHugh never visited the site, right?
He reviewed all the photos.
Did he never visited the site?
Well, now there's no trench left.
So no, he didn't go.
Right, but he reviewed all the evidence, including the deposition transcripts, which has the accident report in it.
So the plaintiff testified that he enters the trench as he's told to jump. He stepped into a foot or two of mud. He used his shovel for leverage. He took one step off the concrete to enter the trench. The concrete underneath him collapsed, forcing him down.
Right, as he's stepping down, the concrete collapses, and that's why he fell into the trench.
But had he been stepping on a ladder into the trench?
That would not have prevented the concrete from collapsing, so there's a clear issue of fact on
How
whether...
do you handle the plaintiff's expert that indicates, what evidence do you have to rebut what the plaintiff's expert indicated, that a safe means of access to the trench would have been a ladder or some sort of ramp?
Mr. Fuchs, his entire opinion is based on an assumption that it's a 5 or 6 feet trench, which is against the evidence, and he does not opine on how or if a ladder would have been a proper safety device if it was only 1 or 2 feet or 3.5 feet, or the other depths that different people, including plaintiff, describe the trench at.
Thank you.
Thank you.
Just briefly, Your Honors.
Counsel, do you agree that the concrete collapsed before the plaintiff entered the trench?
I don't think that that's actually accurate based on his actual testimony, but I don't think it's...
That was his testimony.
I don't
He
think
said
it's...
as he was stepping off the concrete that it It collapsed.
Under either version, however you want to determine whether the concrete, he stepped on it or it fell afterwards, that's all irrelevant. The main issue here is he was not provided a safe means of access to the trench that everyone on site agreed with. Brian Laurie and their own accident report specifically said we need to provide safe access to the trench through means of a ladder. So under any particular version, whether he's stepping on the concrete itself, there was never a specific instruction that he wasn't supposed to enter the trench that way. The only evidence that we have here is that a ladder was the necessary safety device to enter
How
the
would
trench.
the ladder have prevented the collapse of the concrete?
He wouldn't have had to step on the concrete.
Because the ladder would have been placed directly into the trench, and therefore he would just use the ladder, go into the trench, and not the concrete.
Correct. So provides a safe means of access. And then just one more point, Your Honors, briefly, just this idea that if it was 2 feet based on the expert, obviously it's 6 years after the fact, we shouldn't consider it. There's plenty of case law in the First Department from 2 foot, a whole case from Haskins from last year. Judge Rosado was part of that panel, which found a sufficient elevation-related risk. Thank you, Your Honor.
Thank you. Honeywell Partners v. Deloitte transactions. Yes,
Afternoon.
please
May I
proceed.
Timothy Hoffner on behalf of Appellant, Deloitte. The straightforward question for the panel is whether a claim by a third party to a contract is a third-party claim. The case arises from a contract between Appellant Deloitte and Appellee Honeywell Partners to prepare a valuation. Park Street GP Limited is a third party to the contract. Deloitte is seeking indemnification from Honeywell.
Seems to me that
Please.
it would have been foreseeable when they were drafting this contract that a third-party claim, if a third-party claim was going to be made, it certainly might well have been made by Park, right?
The court determined that Park Street was a third-party beneficiary
Right,
to the
but What I'm
contract.
saying is when they were negotiating the contract, if they were worried about having liability as to third parties, certainly a third party who might have sued would have been Park, right?
So Park Street was the one party that was identified in the contract, and therefore it was the one party that made sense in terms of the possibility of some third-party claim being pursued, which is why the court's decision below doesn't make any sense, because he
So if Honeywell had been concerned about that, that's certainly an issue that it could have raised in negotiations with Deloitte.
And let me put it the other way, that the Park Street and Honeywell negotiating could have carved Park Street out of the contract.
That's what I was asking. Right?
Yes, no, that's the key point. So Justice Reed agreed that the contract applied to third-party claims at R51, construing the indemnification clause as pertaining only to third-party suits affords a fair meaning to all of the language employed by the parties. Honeywell conceded the indemnification, quote, clause protects Deloitte against third-party claims. R235, nonetheless, the court made this determination. And I think the judge was confused, and he based his decision on the fact that both Park Street and Honeywell were suing together. The facts are relevant. There's not a single case that supports that as a determinative factor, and so Honeywell for sure doesn't cite any case to support that. So by his determination, he's effectively carved out from the agreement both intra-party claims and third-party claims, which would render the indemnification clause that was negotiated for by Deloitte, it would negotiate out of the contract. That's inconsistent with New York law. We cite at length to the Revco decision from Judge Rakoff, a very well-respected judge in the Southern District of New York, which is squarely on point. It does away with Honeywell's argument that Park Street's third-party beneficiary status somehow exempts them from the indemnification clause. The key quotes in that case are, the court recognized a third-party beneficiary does not by that status become a party to the contract. The court recognized that third-party beneficiary status has no bearing on whether one party to a contract is required to indemnify the legal expenses of a second party to the agreement related to the claims of the third-party beneficiary. And the court concluded that the indemnification claim for both fees and a damage award could proceed against the third party.
If Park Street's claim for indemnification was excluded, where would this indemnification provision apply?
If the claim against Park Street is excluded?
Yeah.
Again, I think that Park Street is really the one party that is affected by the valuation services that were being performed by Deloitte. So realistically, we don't see where there would be a claim that would be, that would exist, which is why the court's decision doesn't make any sense to us. The parties, Honeywell relies on the Hooper.
If this provision was meant to cover anything, it would seem to have been meant to cover something like this claim emanating from Park Street.
Again, Park Street is the one party that is affected by the valuation services that are being performed by Deloitte. So it does make sense that the indemnification claim that Deloitte is pursuing against Honeywell should be permitted to proceed. So Revco explained why the Hooper line of cases, which they rely on, Hooper and Sage, don't apply here. Those apply to intra-party claims. They argue that Park Street's identical claims are indistinguishable from Honeywell. That's simply false. Park Street seeks to recover carried interest that it claims would have been paid to Park Street Limited Partnership if Deloitte provided a higher valuation and reimbursement for various payments to Deloitte and to other third-party advisor. That's R162, 163. In contrast, Honeywell seeks reimbursement for the supposed time its employees spent on the project and nominal damages. That's R164. These claims are subject to distinct arguments, particularly with respect to causation and damages. They're very different claims, so their statement is just flat out false. So the exclusion of the third-party claims by Park Street from the indemnification provision would render the provision worthless for the reason that you've both raised in your questions. One last point I want to touch on is Honeywell argues that upholding the claim would gut the agreement's purpose and absolve Deloitte from any obligation to perform its services. This is simply untrue. The indemnification provision does not apply to Deloitte's conduct rising to the level of, quote, gross negligence, bad faith, or intentional misconduct. So Park Street can convince the fact finder that Deloitte was grossly negligent, engaged in bad faith, or intentional misconduct.
Thank you. You have time on rebuttal.
Thank you.
May it please the court, Stephen Mollo on behalf of Honeywell. The trial court found that it would be absurd to require Honeywell, which is the signatory.
Under your theory of the case, where would this indemnification, if it doesn't apply to the claims which arise from Park Street's claims, where would this indemnification apply?
It would apply to situations like where Deloitte was out doing this valuation, they were inspecting the property, somebody slipped and fell, they sued Deloitte, and that would be subject to indemnification. If in fact Deloitte hired or contracted with some other third party to do something.
This indemnification was put there to protect against slip and falls.
Slip and falls and other liability from a true third party. Counsel misstates.
What do you mean by a true third party?
Right. How is Park Street not a third party?
Park Street is a third party beneficiary, and here's the key distinction.
But it's not a party to the contract.
It's not, no, but it's the intended beneficiary of the contract, and the lawsuit that Park Street is bringing is to enforce the basic promise of the contract. So it's not a third party in the sense of.
I asked the question to you.
I'm sorry?
Again, I'm going to ask the question to you that I asked your adversary probably less appropriately, which is, if this was your concern, why wouldn't you have excluded that from the indemnification provision? Why wouldn't you have excluded Park specifically from that provision?
Well, first of all, indemnification is an extraordinary thing, right? Because we're shifting the responsibility for paying for the harm that was caused. So Hooper, which is a New York Court of Appeals case, which is later in 2022 is reaffirmed. That's the law here says that you have to be.
The question is, why not carve them out when you're sitting down and making this contract, knowing all that you know about indemnification? Why not carve out
It's not
Park Street?
necessary because they were suing. It isn't necessary because they were suing on the promise of the contract. They were bringing essentially a direct action.
Suing on a promise of a contract that they're not a signator on.
They're not a signatory, but they're the intended beneficiary. May I explain just how the contract works? So Honeywell is affiliated with Park Street, basically performing a lot of the activities. Park Street doesn't have a staff or a team of people doing anything. They contracted, signed the contract, and the contract was for Deloitte to do evaluation that would determine how much money Park Street would be owed as between parties having a dispute. So they were the intended beneficiary. Their lawsuit here is being brought to enforce the promise that Deloitte made to provide a proper valuation. So it's not a third-party claim in the traditional sense of a third-party claim. They're suing on the contract.
But
they're seeking to
what
enforce
about
the
the fact
promise.
that, is there any relevance to the fact that the engagement letter specifically states that Honeywell and Park Street are not affiliated entities?
Well, when I say affiliated, I didn't mean it in the sense that it's there in the contract. What I meant is that they're both companies that work together. And if I misspoke, I apologize.
That contradicts what the engagement letter says.
I'm sorry?
But what you're saying completely contradicts what the engagement letter says, which
No,
they sign.
What I'm saying is, in the engagement letter, it's clear that what Honeywell was doing was contracting to have Deloitte perform a valuation that would be for the benefit, the intended benefit of Park Street. And Park Street, as the intended beneficiary, is bringing a claim against Deloitte to enforce the core promise of that agreement.
We understand that. The question is whether the indemnification clause, how the indemnification clause applies to them.
So this is the absurdity which the court, which the trial court noted. All right, the absurdity is that if you believe Deloitte's interpretation, if you accept it, Honeywell, which contracted to have this service performed on behalf of Park Street, would then be responsible if Deloitte caused harm to Park Street.
Right, and that's something that Honeywell could well have foreseen and negotiated to overcome, right?
But, I mean...
Apparently, they didn't foresee it, so they didn't negotiate about it. But it seems to me that if what you were concerned about was slip and falls, then you would have excluded Park Street from the inclusion of this.
No, because that would be a third-party claim, and that's what the indemnification is intended to do. This isn't a true third-party claim. I'm sorry.
Very much drafted in order to protect Deloitte. Its liability is limited to the extent of the fees it collects. And when you look at the indemnification provision as 6B, it doesn't really seem to be contemplating a slip and fall type of situation, and it uses the personnel from all claims.
All claims, but in Hooper, it's actually even broader. It said any and all claims, and in Hooper, the court said that this sort of claim that's brought as a direct action, which is what this is, it's an action to enforce the contract, that it would be absurd to allow indemnification in that situation. It would effectively be giving them a release.
Thank you.
Thank you.
Just a few quick points. Yes, you're absolutely right. Relating to the engagement makes the Park Street claim the one that makes sense here. Hooper has nothing to do with this. That is an intra-party claim, meaning a claim between two parties to a contract. Revco is the relevant case. We also cite four New York
Appellate.
Appellate.
The issue is, right, counsel? Because initially, when you started the action before the Supreme Court, you were raising that intra-party indemnification.
We did, and we're not appealing that decision, and we've just focused on the
You lost
claim.
on that and you accept the loss. You lost on that issue and you accept the loss.
Yes, sir. But the key is Revco is directly on point on this third-party claim issue, and we also cite four cases three from the First Department, one from the New York Court of Appeals. We've got LaSalle, which are very clear that third-party beneficiaries are not a party to the contract. but third-party rights under the contract. Where I was before, in terms of the absurdity of it, it would only be absurd if we're not permitted to pursue some indemnification claim, the one that is logical under the agreement. The contract was very clearly drafted with a symmetry to it, where there was a limitation of liability that limited any claims against Deloitte except for gross negligence, intentional misconduct, or bad faith. Deloitte's not making a huge amount of money on this, so there's a limitation of liability to the fees. The indemnification provision is exactly parallel to that provision.
There seems to have been an attempt to cap its liability at the extent of its fees.
Exactly. That's exactly right. And that's what the two provisions working together, and then there's some other language about consequential damages, et cetera, is intended not to give Honeywell or someone else, I'd call a lottery tickets or some crazy thing, which is what they're in fact pursuing in this case.
Thank you. Thank you both.
Thank you.
Bolcom v. BUFNY 2 Associates. Whenever you're ready.
Good afternoon, Your Honors. My name is Guy DeRosier, Wilson Elser, representing the appellant respondent BUFNY 2 Associates LP. The facts of this case, which are highly unusual, to say the least, present, I believe, an interesting procedural due process.
I'm not sure which part of it you think is unusual. We see default judgments entered all the time against companies that haven't updated their address for service of process with the Department of State. So your facts are a little bit of a tweak on that, but the underlying, or so the major issue here is something we see with astonishing frequency.
Yes, definitely the fact that some people don't update their address, but this is different. This is different because the address that was on file with the Secretary of State at the time service was attempted is an address that doesn't actually exist. And the person who had filed this address with the Secretary of State was someone who was not authorized to act on behalf of my client. So we're in a situation where the person who is serving gets information, and the information came directly from the Secretary of State because the person presented process as they're supposed to do, and they received a receipt from the Secretary of State. This receipt was nowhere to be seen in the papers that were filed with the Supreme Court.
What about the fact that the correct address was listed on their website?
Well, this is Sobro's website, I believe,
Yes,
Your Honor is referring to.
I think it's Sobro's website.
Well, I mean, that just goes to show that if anyone was hiding, they were hiding in plain sight. I mean, there was no reason for, and this is why we're making a constitutional procedural due process argument, which admittedly is quite a rare, as far as I can tell, argument in this kind of situation, is because the facts here indicate that there was a fundamental procedural due process problem. And what I wanted to highlight were like two cases from the US Supreme Court. One is Robinson versus Hanrahan, which is from 1972. The other one, which is extensively discussed in our brief, is Jones v. Flowers. In both of those cases, there were process was served in accordance with the statute that didn't, there was nothing wrong with the statute per se, but it was served under the circumstances where the person was not, that was being served, there was no expectation that it would be reasonably calculated to apprise the interested party of the pendency of the action. This is what I submit we have here, because the information...
So that's reason to vacate the default judgment against you, right? But you're also asking, are you not, for the complaint to be dismissed, but wasn't service upon the Secretary of State, doesn't that provide personal jurisdiction? And now, of course, if the default is vacated, you get a chance to put in an answer and the case will be litigated on its merits.
Well, that's certainly true, and I'm happy to address any issue. We're certainly, you know, my main argument on appeal is that the action should be dismissed because of this procedural due process issue, which again is based on Jones v. Flowers and Robinson versus Hanrahan. And it's different.
I'm having trouble understanding why that leads to dismissal as opposed to a vacator of the default judgment.
Well,
I understand that you claim that you don't know how this got sent to the wrong address and so on, but it seems to me that would entitle you only to vacating the default because plaintiff did everything it was supposed to do when it served the Secretary of State. It's not the plaintiff's fault that the address that was on record for your company was a wrong address.
Well, it's not just that it was the wrong address. It was an address that is, on its face, is invalid. It was New York, New York,
Plaintiff still
11201.
made service in a way that's permitted by law. So why should their case be dismissed?
Well, again, in Jones v. Flowers,
I'm not understanding. You failed to register with the Secretary of State, the correct address, right?
well,
Is that correct?
our client didn't know that this change, certificate of
Kermit
change
had
had been made, right.
Okay, but this is your failure. The plaintiff serves pursuant to the Secretary of State, and you're stating, however, that the action should be dismissed as opposed to simply vacating the default?
Well, in Jones v. Flowers, the issue was exactly, it was something very similar to this.
But why isn't service on the you're raising this constitutional issue, but why isn't service on the Secretary of State provide jurisdiction, comply with due process? Now you come in and say you never received it, and yes, there certainly seems to be validity to that argument because anyone who knows 11201 knows that Bergen Street is not in Manhattan. So that gives you CPLR 317. You never knew about the case. You've got a right to have the default vacated, put in an answer, and go litigate the case on the merits. Where is the constitutional issue here?
If I may just answer that question, there's a direct quote from Justice Roberts in the Jones v. Flowers case that I think explains this difference very well, and I'll just cite it. He says, "It's certainly true that the failure of notice in a specific case does not establish the inadequacy of the attempted notice. In that sense, the constitutionality of a particular procedure for notice is assessed ex ante rather than post hoc." That's what I believe the panel is saying. But, he goes on, if a feature of the chosen procedure, which is what we have here, is that it promptly provides additional information about the effectiveness of notice, it does not contravene the ex ante principle to consider what the person giving the notice does with that information in assessing the adequacy of the chosen procedure. The other case, again, is Hanrahan v. Robinson, where this was the state of Illinois had put this gentleman in jail. The person was incarcerated.
What about the state of New York? Do we have any cases here which would support your argument?
Well, I mean, these cases have been referred to. They haven't arisen in this specific context, but the constitutional law is there. Jones v.
So that's
Flowers.
a no. Thank you. You have time on rebuttal.
Thank you, Your Honor.
I don't understand this argument.
Good afternoon, and may it please the court. My name is Neil Finkston. I'm here on behalf of the plaintiffs, the respondents, and appellants. I'd like to first address the appeal by BUFNY. Service was properly effectuated under the partnership law. Delivery was made to the Secretary of State. That really should be the beginning and end of the entire appeal. Everything else that the defendant is saying.
CPLR 317 figure into that?
I'm sorry?
Where does 317 figure into?
Well, there are some additional facts here that didn't come up during my colleague's argument that I'd like to discuss, and I think addresses your point, Justice Friedman. Mr. Eady isn't the reason that BUFNY's address with the Secretary of State is incorrect. BUFNY relocated in 2005, they say, and then they never updated their address. The original address, Adam Clayton Powell Boulevard, that's what was on file when Mr. Eady made his filing. This was never a situation where BUFNY had on record the 555 Bergen Avenue address that they claim. So the duration of time where they didn't update is actually from 2005 all the way through the commencement of this case in 2014. But what they did file, though, is a document with the Secretary of State to change the composition of the partnership in 2005. They clearly recognized that something needed to be done with the Secretary of State, but they didn't change the address for service.
And at that point, they would have had to look at what was on the Department of State records in order to file something, right?
Respectfully, no, Your Honor, because it had nothing to do with Mr. Eady, because as far as they knew back in
Right, but if they were going to file to make another change to their Department of State filing, they would have to look at what was currently there,
well,
wouldn't
they had relocated, so they know that that wasn't the address when they were initially.
I think that was the point.
I'm sorry?
I think the point was in making the modification, they should have seen that.
Oh, I
they
apologize.
should have
I missed-
updated
I missed-
Should have updated the address because.
I apologize, Your Honor.
The filing should have shown the address, and therefore they should have been on notice
Yes.
that that was the
So
incorrect.
prior to the commencement of this case, there's a 9-year gap where they don't do anything. They do change the composition, and then they're served with another complaint in another case in 2022 that clearly states the supposedly incorrect address from Mr. Eady, and yet they still do nothing to change the address. So if there was ever a question about whether they had updated their address for purposes of service, they certainly knew about it in 2022, granted after the commencement of this case, but it does support the pattern here that they do nothing. So this idea that this was an innocent mistake and we didn't know, I don't think they can make that argument because they did know. Sobro is an even worse example because prior to the commencement of this case, Sobro, which relocated in 2002, had received service, prior service in another case prior to the commencement of this one, which stated their old address on 149th Street in the Bronx. And they didn't do anything. And then 3 years later, this case is commenced. And that same address is on file with the Secretary of State. And then over the course of time after the commencement of this case, there are 4 more cases that they receive. Admittedly, they receive it. Summonses stating their address at 149th Street. And nothing happens. So this is a situation, both defendants, not identical, but certainly similar in rationale, that just didn't want to be served. And there's no
Sobro's
explanation.
Is
Sorry,
on
Judge?
their website, right?
I'm sorry?
Sobro's address is on their website, right?
They submitted documentation that indicated that the address was changed. We would say to that, there's no burden on a plaintiff to start doing a Google search or an internet search.
No,
to
but it
locate-
goes to whether, in fact, they were trying to hide where their address was.
Well, and we would say, though, that,
And whether it was an honest mistake, oversight.
yeah, I think that argument puts plaintiffs in a bind because they're publishing one address, yet the Secretary of State, for service purposes, has a different address. And
I
if
mean, is it a bind or is it just a simple Google search?
But it still doesn't solve the problem of where is this defendant for purposes of service to the Secretary of State.
Yeah, but it brings up, when someone comes in on a 317 motion and says that we never knew about this case until the default judgment, and the evidence seems to support the fact that they never knew about it, and Sobro's address is on a public website, which could have been checked and they could have been notified at that address.
Well, again, the defendants are in different positions. Sobro received service in another case that stated the old address. They can't claim ignorance about that, and there's nothing submitted by any representative. I see I'm short on time.
Yes,
If
you're
I could
fine
just
on
answer
rebuttal.
I just answer the question, Your Honor?
On rebuttal.
Okay, thank you.
Good afternoon, Your Honors. Tracy Frankel on behalf of Sobro. The court below understood that justice in this case would be served by allowing all parties to have their day in
Counsel.
court.
Corporations operate under a set of rules, and one of the rules in our state is that corporations have to list an address for the service of process with the Secretary of State and update it when necessary. Sobro apparently relocated in 2002 and didn't bother to update its service for its address for service of process for more than 20 years. And now it comes in and says, oh, too bad there was a default judgment against us. You should vacate it because we didn't bother to fix it. Why should we do that?
Because the court did not make its decision under 5015 where that factor has a place in the analysis. Instead, the court viewed it under 317, which was specifically stated in the commentaries of 5015 to avoid dealing with a mistake in not re-registering. And I think that the legislature and the court in this case recognize that people make mistakes and people don't necessarily know that they're supposed to be filing documents with the Secretary of State
What about your
to update.
adversary's argument that there was other service of process that you in fact received that listed an incorrect address, which should have alerted you that there needed to be some sort of correction?
The only case that the plaintiff cited that predated this service was Castle. And the distinction between Castle and other types of cases is that the Sobro received those documents also at its correct address. So when you receive papers in the mail and you read them and you're looking at the substance, you're not necessarily looking at what addresses are in a service list because you're looking at the document and then you're sending it to your insurer. So there has to be a clear evidence of an intent to avoid service, and Castle alone, because it was also received by Sobro in the mail at its correct address, just doesn't show that their lack of knowledge of the rules for the Secretary of State was an intentional one, especially considering the fact that they would communicate with the Secretary of State on letterhead with their correct address. And if they were trying to avoid that,
You're suggesting the Secretary of State should do a correlation between what's on its website and the addresses of letters it receives?
no, I don't think the Secretary of State is at fault here at all. My point is that there was no intent to avoid service or hide it from either the Secretary of State or other individuals or entities who might be looking to serve them with process.
And your point is that if there wasn't an intent to avoid service and you established that you didn't know about it, then under 317 you could get relief.
Well, no, actually, because under 317 and the case law, you don't even need a reasonable excuse for not re-registering. It's just not a factor. 317, there's a two-factor analysis.
I didn't say, I said if you established that it wasn't intentional, that you
Yes.
weren't doing it to avoid service, and you show that you didn't receive it, then you can get relief under 317.
In essence, yes. I mean, it is the burden of the plaintiff to establish clear evidence, and they didn't, so that wouldn't be our burden, but we certainly raised evidence to the court, which on balance with everything else, pointed to a lack of knowledge. In fact, the plaintiff acknowledged in their underlying papers to the court that it was apparent, was the word that they used, it was apparent that Mr. Weinbrecht didn't know the Secretary of State rules. And so they avoid using that sentence again in their brief, but that lack of intent was apparent not only to the plaintiff in the underlying court, but in the underlying arguments, but it was apparent to the lower court when they decided to vacate a $16 million judgment against a party who established that they have very real defenses to the lawsuit. Thank you.
Thank you, Your Honor. Very briefly, on the estoppel argument, because that is essentially the argument that they're raising, that we should be stopped from using 317 because of a willful failure. They only,
That's estoppel, but,
well,
but based upon that argument,
right.
continue.
It's essentially an estoppel argument. The only case they could find against our client is a
You
judgment.
just said, I don't know that that's an estoppel argument, but
I-
you said it's basically an estoppel argument. Yeah,
I apologize, Your Honor.
Continue.
The case that they rely upon from 2022, where the service of process was admittedly made, or apparently made through the Secretary of State, the record shows that my client received a copy of that because a copy of the summons and complaint was actually sent by certified mail to 555 Bergen Avenue in the Bronx, which is my client's address. So unlike the plaintiffs, this plaintiff's counsel was able to find my client. Nobody was hiding here.
When was that sent?
Sorry?
When was that sent?
This was in 2022, but it's, I mean, again, this accident happened in 2013, so it's a long time between those two facts. There's simply nothing in the record here that shows any intention to avoid service of process in this case. Just getting back very quickly, and I'll rely on my brief for the proof of the meritorious defenses under 317. I think we've covered that, I think, quite well, both under Labor Law 241, 241-6, as well as under the negligence causes of action. But the last piece of the puzzle, again, getting back to this constitutional argument, the plaintiffs used this non-existent address for 8 years. 8 years. This is a law firm that's based in New York. They know that New York 11201 is not a real address. When they served on the Secretary of State, they got a receipt saying this is where it would be sent. They continued using this address for 8 years in all correspondence relating to this case.
Thank you all. I'm sorry, you have 2 minutes on rebuttal.
May it please the court. Just very briefly to touch on the arguments from my colleagues. With respect to Sobro, I refer the court to the C3 data case that we cited in our reply brief, which was decided by this court back in January, which upheld the denial of relief under 317 to a defendant who had been served with process in another case, a prior case, showing an incorrect address, and then no steps were taken. That's the same situation that we have here. Sobro clearly knew that the address on file was incorrect. With respect to the Castle case, the prior case, it stated the wrong address. So whatever arguments actually both Sobro and BUFNY want to make about how they ultimately got the set of papers, they were clearly on notice that the address that was still on file with the Secretary of State was not correct, and then they did nothing.
You're saying that they're clearly on notice. Is it because on some document or piece of paper, it lists the places that were served?
Yeah, I think that's sufficient under the case law to show the case law that refers to a defendant's receipt of process in another case that alleges, that states a principal office at a certain address is sufficient under the case law to advise a defendant that they need to change the address for potential litigation and for potential plaintiffs. And with that knowledge, certainly Sobro did absolutely nothing. And as far as BUFNY's, again, a different situation, but still compelling, they filed documentation to change the composition of the partnership, not the address of the partnership. Then, when they did receive process in the 2022 action, after this one, they did nothing. So claims of innocent mistake and we want to make ourselves available to plaintiffs just rings hollow given what actually happened, which is the defendants did nothing to make it available, make themselves available for service of process. And unless there are further questions, we'll rely on the arguments in our brief.
Thank you.
Thank you.
Rabbaza, the 165 E66.
May it please the court, Stefan Kalina, Cox, Padmore, Skolnick, and Tricarci on behalf of the appellant. On de novo review of this dismissal of a motion, dismissal of the complaint of 3 causes of action asserting 3 independent failures under the contract at issue, that dismissal should be reversed. Judge Schechter, in issuing her decision in dismissing the complaint, reduced plaintiff's remedy under the subject contract to a simple choice of either terminating.
Did the judge do that or did the contract do that?
We believe, Your Honor, that the judge misread the contract. The contract makes a distinction with an absolute difference between information that one receives post-execution of the contract prior to closing, which is the case here, and a misrepresentation by the seller. Section 7.16, Romanet 3, by its terms, make a distinction between receipt of information that relates to a representation and whether that information causes a breach thereof. And what we believe Justice Schechter did is say that, and her language is clear on the point, if you have sufficient concern or a discrepancy, is her language, and that is echoed in the opponent's brief, then your remedy at that point is to terminate or continue with the contract.
But the judge pulled that from the actual contract provisions.
She conflated, respectfully, Your Honor, the idea that the purchaser could terminate on a misrepresentation with receipt of information that may relate to a representation that might be breached. And while it sounds, quite frankly, that I'm waltzing on the head of a
What's
pin.
your remedy if that happens?
I apologize, Your Honor.
What's the remedy under the contract if that happens?
At that point, in order to effectuate the remedy of determining whether the purchaser could terminate or proceed, they would have to receive information regarding the inconsistency or the discrepancy. And
What provision of the contract gives you that remedy? What section? Tell us so that we can
tell us
look
the
at
number
it.
on the record.
And I understand Your Honor's question. So if we look again,
So please answer the question.
Certainly.
What's this, where? Where
Where
is
in
this
the
at?
record?
certainly. If I can direct Your Honors to page 105 of the record, 7.16, and more specifically to Romanet 3 at the bottom of the page.
In the event that prior to closing, purchaser shall obtain knowledge of any information that is contradictory to and would constitute the breach of, the basis of a breach of any representation or warranty or failure to satisfy any condition on part of the seller, then promptly thereafter, and in all events prior to closing, purchaser shall deliver to seller within 5 business days after knowledge thereof, notice of such information specifying the representation, warranty, or condition to which such information relates.
Correct, Your Honor. And the point.
You can't read that section by itself in a vacuum. You have to read it in conjunction with the entire contract, right?
Like, yes, like
We could.
the section prior to it, right? And also 7.19.
Yes, and I think that a fair reading of the contract, a correct reading of the contract, would harmonize with those provisions and expose Justice Schechter's erroneous reading of the contract, and I can explain why. First of all, the
Tell us what was erroneous. What exactly are you claiming was erroneous? How did she read it wrong?
as her decision or transcript of her decision indicates, that the purchaser has to fish or cut bait on sufficiency of concern, on receipt of information, or a discrepancy. Those are the terms that she uses in the actual transcript. And that's echoed and that's quoted in opponent's brief. But if you look back at 7.163, if I may, again at the bottom of the page, if the purchaser shall obtain any knowledge or any information is contradictory to and would, which is a conditional term, constitute the basis of a breach of any representation, not misrepresentation. 7.19 refers to the termination remedy as being triggered on a misrepresentation. And 7.16 Romanet 3 is clear according to its terms. One, it doesn't include the term misrepresentation. And furthermore, at the top of page 106 in the record, the notice of such information specifying, again, the representation to which the information relates.
But isn't the underpinning of your claim the fact that the rents that were being received or the information that you had regarding those rents was a misrepresentation, and you wanted to get more information about that to determine whether to terminate the contract or go forward with the contract?
May I respond with the?
I don't know.
Thank you. Your Honor, if I understand the question correctly, the thrust of our complaint is that we did not receive the information to determine, in line with 7.16 Romanet 3, whether that information relates to the representation of the rent roll, which is dated 2023, if I may, and the RPIE filings are 21 and 22, that give rise to a discrepancy. That does not mean that as of yet, a misrepresentation has ripened, and it's the misrepresentation that is the trigger for the remedy under 7.19 and furthermore 9.22, which I can address in rebuttal if I may.
Yes, thank you.
Good afternoon, Your Honors. Scott Mullen for the respondent. I thank you for your patience in advance.
In advance?
It's hopeful.
Counsel, I have a question.
Sure.
By executing the agreement, didn't the purchaser also acknowledge that he examined and inspected the tenant's files and any other requested document under section .51?
Yes, and it was worse than that. The answer is, like many sellers who are concerned that if you sign a contract and there's a dispute, the buyer could slap a lis pendens on the property and cloud title and tie it up. So like many other sellers, this seller said, go do your due diligence ahead of time. And not only did they say that, they made the purchaser represent in the contract that they had done the due diligence, that they saw every document that they thought was necessary that they asked for. And they spelled out, including leases, including profits, including operational expenses. Everything was spelled out. And they also required the purchaser to represent that they are a sophisticated real estate investor, particularly with commercial property in New York. And Judge Schechter simply, even though they've come up with several attacks, which usually, or I shouldn't say usually, sometimes means they don't have one good argument, is the fact that repeatedly throughout the contract, it says there'll be a sole remedy. What is ambiguous about sole remedy? And the sole remedy is if you find an inconsistency, you have, before closing, you have the option to either close or to cancel the contract and have your deposit refunded. So that was the protection.
It seems like the argument that they're making is that they were on the cusp of finding a misrepresentation, but before they could do that, that this section 7.16 says that with regard to representations, that they're entitled to other information.
Right, that apparently that they are entitled to information and that you were to supply them with information which would lead to a conclusion one way or the other as to whether there was in fact a misrepresentation.
It's exactly correct as to what they argued.
Right, but I don't see that there.
Justice Schechter kept saying, point me to the language. She spent 33 pages.
Does the contract call upon your client providing further information after the contract has been entered into?
I'm sorry.
Does the contract call upon your client being required to provide them with more information after you've entered into the contract?
It only has the typical reasonable further assurances provision to execute ancillary agreements. It wasn't an open-ended information.
But not that you're supposed to turn over any additional documents
No,
or
the documents were
information.
turned over before.
Before, and they represented that they had it. And on top of that, they're ignoring the leases were not a condition. In fact, they went.
Well, they're claiming that there was I think you were receiving rent from one of the unit's tenants that differed from what was contained in the tenant's written lease. Apparently, there was an oral agreement with another tenant to pay a substantial amount of back rent based upon caused by COVID, and then there was a issue with one of the units that was occupied by a restaurant that did not have a lease at all.
You just quoted from, I believe, the affidavit of Mr. Rabbaza. It is so absurd because if you look at the contract was so thorough in protecting the seller. The contract actually said, we are not representing that any leases will be in effect. We are not representing that any lease will not be in default. That's paragraph 7.1.6 at 105 of the record, and 7.1.5. And if there is any inconsistency, the contract went further and said it will be deemed, the representations and warranties will be deemed to conform. And that's repeated throughout the contract.
Counsel, when we inquired of your adversary as to where their argument was coming from in the contract, they referenced 7.16 subsection III. What role does that play in this argument at all, if any?
It really plays none. Your Honor made the point that you have to look at the contract as a whole. Repeatedly throughout, they say, we're not making reps, we're not making warranties, and by the way, we explicitly contemplated, the parties contemplated there could be inconsistencies, there could be misrepresentations even. And the contract said, in that event, you can cancel, walk away, get your money back. We'll give it back to you, or you close. But the seller was very concerned, like many times you see in New York, this is a very sophisticated court, I know that. You see people, they couldn't get their money together to do a purchase. They decided the market's getting softer and they want to renegotiate the price. So you look to find things that are misrepresentations. And this seller protected itself repeatedly throughout this contract. You look at the language of the contract and you match it up with the arguments, they just don't match.
Thank you.
So respectfully, as I indicated at the end of my initial remarks, can we please look at section 9.2.2, which refers to at closing, if in fact the representations are found to be incorrect or false, so therefore there is an exact and express contemplation of there being misrepresentations and not under the scheme that my adversary is saying as if they've been absolutely precluded and foreclosed at the time you get to closing. If those misrepresentations amount to a material adverse effect, meaning a 25% reduction in the purchase price at seller's election, sole discretion, they can then reduce the price to cover the damage that the misrepresentation would have caused, and thereafter the contract is expressed, those claims for misrepresentations would then be foreclosed. To suggest to the court in any way, shape, or form that the atmospherics or New York real estate directs it.
Discover a misrepresentation, that if you discover a misrepresentation before closing and it affects the price by 25%, the seller has the option of saying, well, you've got to close and we'll make up the loss.
Your Honor, respectfully, in your question, you referred to before, but this contract scheme is express that information can come to light post-execution and prior to closing.
So it's got to be before, because however, if on the closing date, any such representation warranties are not true and correct in all material respects, purchasers shall in any event be required to close. So it's obviously speaking about pre-closing, because post-closing, you have no rights.
But it's and it specifically says if purchaser knows at or prior to closing.
Your Honor, I agree with you. The distinction I was drawing was, and it was referenced in my adversary's remarks, is information in due diligence, which is prior to execution. This contract has an express scheme for information that comes to light after that due diligence period, and yes, I would agree. Of course, it's prior to closing, but it's based on that information that comes to light post-execution, prior to closing, and then there's a remedy for it. And I'd furthermore agree with Your Honor.
So what's the import of that? What is the legal import of that argument?
That Justice Schechter did not harmonize 9.2.2 with 7.16 to suggest that upon receipt of information only, then the purchaser has to decide to risk losing its money or risk losing the project. That's not what this contract says. On its terms, that there is information that comes to light after the fact. It's been demonstrated factually that the rent roll that was in the contract at execution differed then from the pre-closing deliverable of the RPIE filing, which would then trigger the remedy potentially under 9.2.2 And Justice Schechter read that.
Were you not in possession of the rent rolls prior to the contract and closing?
The rent roll, yes.
So were you not aware of the 3 things or 4 instances that you pointed out in terms of the restaurant, in terms of any oral agreement, in terms of the lease?
So no, because the rent roll would report the rent received by the landlord. And then the RPIE filing under 8.1, I think it's 11, that's delivered after the due diligence period, prior to closing, reported a different amount of rent. And that's where the discrepancy arises, and that's where the textual aspect.
And when did you come in possession of that information?
Prior, it was a pre-closing deliverable.
So that's the misrepresentation that you're speaking of, and your remedy for misrepresentation is to go forward or get your money back.
Respectfully, Your Honor.
As per section 9.2.2 of the agreement, where it provides that if purchaser knows at or prior to closing of any representations that are inaccurate, untrue, or incorrect.
But the information in the RPE filing relates to the representation about the rent roll, but there's no explanation yet as to whether it is a misrepresentation or it's explained away. And I just, lastly, and I won't go further.
Fault at that point for having failed to pay the second deposit?
No, because it's set forth in our briefing and in our pleading, which this is a pre-answer motion to dismiss, which is afforded truth of the allegation that the seller waived that by their conduct by continuing with the transaction.
Thank you. Victor V. Casovich. Casovich. I'm tired. I'm so tired.
You're doing great.
So tired. Oh. Yes.
Good afternoon, Your Honors. May it please the court, my name is Daniel Gomez-Sanchez, and my firm represents Appellant Manhattan Place Condominiums in this appeal. There's one issue on this appeal, and that is whether or not the lower court erred in failing to grant MPC, Manhattan Place Condominium, summary judgment on Tyler Erdman's first counterclaim for retaliation under the New York City Human Rights Law. That question, we believe, should be answered in the affirmative, reversing Judge Hagler's April 17, 2023 order and entering judgment in favor of MPC. The New York City Human Rights Law is clear in its mandate. It protects enumerated classes from discrimination and harassment and retaliation in the areas of employment, housing, and public accommodation.
And the plaintiff in this case doesn't fall within any of those classifications, correct?
That's correct. The counterclaim plaintiff, Mr. Erdman, does not fall within any of those classifications. That's 100% correct. The law and the city's own website specifically make this clear. It applies in those 3 areas. So Section 8-107, the New York City Human Rights Law in its totality applies to those 3 areas, at least in respect to Title I, so apologies. So plaintiff's contention is that the New York City Human Rights Law's anti-retaliation provision applies to any person, irrespective of the City Human Rights Law's specific limitation to public accommodation, housing, and employment. And we believe that this is simply erroneous. In fact,
There's no case law that supports that.
there is no case law to support Mr. Erdman's contention. In fact, Judge Hagler ruled in a separate case, Casovich v. Victor, wherein he granted summary judgment in favor of MPC in that matter, and then on re-argument asked Casovich's counsel, is there any case law to support your position that Ms. Casovich, not being an employee of MPC, can proceed with a retaliation claim under the New York City Human Rights Law? To which, in the court's opinion on re-argument, Judge Hagler specifically says that plaintiff's counsel, Ms. Casovich's counsel, could not point to any law at all to support this contention.
When was the date of that decision?
That date of that decision was November 11th, 2024. So, Your Honors, Mr. Erdman also posits that to the extent there is some sort of employment relationship that he can point to, there are no facts within the record to identify him as an employee. In fact, what the record does demonstrate is that he was performing services for Manhattan Place Condominium through his company, Aerotainment LLC, in which at the time in 2013, 2014, in other words, before 2020 when the New York City Human Rights Law was amended to cover independent contractors, he was performing services through a company. And in this court's opinion in O'Neill, this court specifically held that the New York City human rights law does not protect individuals who are operating as independent contractors through an entity. In other words, the law only protected those persons who were natural persons, independent contractors.
Well, in his affidavit, he states he was working with them from October 2012 until August 2013.
On 3 short-term projects, Your Honor, and those were being done specifically through his entity, Aerotainment LLC, which under this court's precedent in O'Neill would bar any action under New York City human rights law. So unless the court has any questions for me, I'm happy to stand up on rebuttal.
Thank you.
Thank you.
Hello, Your Honors. I'm appearing pro se, Tyler Erdman, as the respondent. What MPC is trying to argue starts a slippery slope that would nullify a lot of the protections afforded by the New York City human rights law. Section 8-107, subsection 7, prohibits any person engaged in any activity to which this chapter relates, such as MPC being an employer, to retaliate against any person because that person has opposed any practice forbidden under this chapter, filed a complaint, testified or assisted in a proceeding under this chapter, or commenced a civil action. And it goes on further to state that it doesn't need to result in an ultimate action for employment, but has to be reasonably likely to deter a person from engaging in protected activity. In this instance, I've checked almost all of those boxes. I oppose the harassment and discrimination by Mr. Victor, MPC's president at the time. I had helped Ms. Kachkevich to retain lawyers and bring a complaint against MPC and Mr. Victor. I had testified by submitting an affidavit on her behalf, and in response, I was sued by Mr. Victor, and he began a decades-long campaign of trying to target me with the hope that by forcing me to incur legal fees, I would be bankrupted and forced to kick Ms. Kachkevich out of my house or be arrested so I wouldn't be able to testify. His goal was that the girls would not be able to have their day in court because they would no longer be in the country. I commenced a civil action by
Would not have their day in court?
Ms. Kachkevich. He had hoped that the plan was that she would be deported because she had an H-1B visa from him that he hoped to revoke in retaliation for her leaving his employ. He did so by trying to petition various law enforcement agencies to target us.
So for retaliation, we need some type of employment relationship. Where in the record do we have an employment relationship between you and, is it MPC?
So I don't believe that the employment aspect is required for this because Mr. Victor is trying to retaliate against Ms. Kachkevich, who brought an action, and I was helping her as a friend to testify and bring that action. And the law doesn't require an employment action. And if
but it does. It requires some type of relationship, which would be an employment relationship. And so, what would MPC? So again, what is your employment relationship with MPC?
So I had been working for Mr. Victor, and he encouraged me and others to form LLCs and to bill MPC. They act as if this was a limited engagement, but what Mr. Victor did was bill an insurance policy related to Hurricane Sandy. So he instructed us to bill lump sum payments in large blocks so we can make...
So your friend states that, the attorney for MPC states that you were working through another entity and you were being paid by this other entity.
That entity was my own, it was just solely me. But I don't believe the employment relationship is required because they're retaliating years after the fact. The evidence that Justice Hagler was considering in relationship to this motion happened in 2019. I ceased working for them in around 2013. Their retaliation was designed to punish me and stop me from asserting my rights under the human rights law and Ms. Kachkevich to do the same. The employment just is irrelevant as the case law lacks in this area because there are very few examples where an employer would spend years after the fact trying to retaliate against someone outside of the employment relationship. They just wanted to hurt me personally and to stop these cases from moving forward. It's just not related to the employment relationship itself. And similarly, they point to 807-102, which defines employer and the natural persons argument that they raised. That subsection specifically mentions what sections it applies to, such as 1, 2, 3, 11A, and 22, and it specifically leaves out section 7 for retaliation. The choosing of any person in the retaliatory statute is meant to make sure this protection extends to as many people as possible because the city council can't can't reasonably write a law to protect in any instance. They had to leave it open-ended. Otherwise, someone could just retaliate through a spouse, a friend, a lawyer, go after anyone but the person to retaliate to try and achieve their goals. In addition, the liberal construction mandate of the human rights law also requires that this law should be interpreted rather broadly to afford these broad protections. As I said, I believe the any person terminology dictates. MPC had failed on their summary judgment motion in part because they did not respond to the counterstatement of facts at all. The court was reacting strongly to that because the court described the retaliation as being in black and white, as far as MPC's attorney going out of their way to work on what was described as the criminal aspect of targeting me. This criminal aspect supposedly had no connection to MPC other than the goal of trying to hurt me and create a chilling effect for me to assert rights under the New York City human rights law.
Thank you.
Unless the court has any questions, we'll rest on our submissions.
Thank you.
Thank you.
Both. Welliver v. TC, the Colorado. Yes.
May it please the court, my name is Michael Lizzie. I represent the plaintiff and appellant Kathy Welliver on this appeal arising from a slip and fall on a large accumulation of water in a laundry room. The plaintiff, Ms. Welliver, appeals from the granting of summary judgment to the laundry contractor Hercules. It stands by the lower court's decision to deny the summary judgment motion of the building owner, the Colorado, and its manager, the Dermot. Hercules was found not to be liable by the lower court because it was a licensee, not a possessor or controller of the property of the laundry room in question. Hercules, however, assumed a duty of care under the principles enunciated in the Espinal.
In your complaint, did you allege that Hercules, or even in the bill of particulars, did you allege that Hercules created or exacerbated a dangerous condition in terms of the repair of the washing machines?
I believe we did. I believe we did use the word created, that they created.
Well, did you talk about anything in terms of negligence by Hercules in the maintenance or repair of the washing machines?
I believe we did.
Because I'm looking at the complaint here.
Our bill of particulars is.
I'm sorry?
The bill of particulars is pretty extensive.
Yeah, I didn't see anything in the bill of particulars either, but let me continue to look and you can continue to speak.
It's a good place. The evidence here amply supports that the conclusion that Hercules violated the license agreement by failing to maintain the machines.
What provision of the license agreement are you claiming that it violated?
8A, where it says that they have to keep they have to service and maintain the machines in good and clean operating condition. And then it goes on to say that
There's no provision about how often it has to check or do anything like that, right? There's no time limitation or specificity with regard to that, right?
it implies a continuous obligation, and respectfully.
How does it do so? Where it doesn't state that, it doesn't.
It says it's to me, well, let's look at it. It says,
How would a continuous obligation to inspect make Hercules liable to the plaintiff?
it's duty to inspect. Well, if their obligation is to maintain the machines in good operating condition, then that is an obligation that is a continuous obligation that they've assumed under the license agreement. So if there's this is a very simple machine essentially. Water comes. It's a fill and drain hoses and valves, and a,
Did the plaintiff know anything about Hercules?
did my
Did the
client?
plaintiff know anything about Hercules?
Yes, there are signs all over the laundry room that indicate that Hercules is the laundry contractor. So there's simple machines. There's a fill and drain hoses and a seal at the front of the door. So these are front load washing machines. So those are the
There's
mechanisms.
no relationship between plaintiff and Hercules.
None. So, I mean, if there's a loose connection or a hole or break anywhere there, you've got a leak. And
Well, the door is also supposed to close, and
Yeah.
the door is not supposed to open unless the washer has finished, right?
correct,
Okay, and there's a sealant there as well.
correct.
Okay, so on this particular day, she testifies that there's water there. However, I thought TC Colorado as well as Hercules, they all say that I think TC Colorado said that they mopped the floor. There was no sign of any water on the floor. There were no complaints about the machines not operating properly. Hercules states that it fulfilled its contract. It serviced the washing machines 2 months prior to the incident, resolved any issues, no complaints. And also, apparently, after the accident, they checked the machines, inspected the machines, and found no leaking machines.
All right, there's a lot there. So let me start with water on the floor on a continuous ongoing presence of water on the floor testified to by.
How would
by
that
the
be
tenant.
Hercules' responsibility in terms of water on the floor?
Well, because it shows, it demonstrates that once you take it in the context of all the other evidence, that there's no other explanation but that the machines are leaking.
But
And it-
Hercules'
How do we
obligation
know-
under the contract is that if it receives a complaint, it goes and checks it.
But it has a
And
separate,
it did, every time it got a complaint, according to the record, it went and inspected the machines and either fixed them or found no problem. And there was I didn't see any indication in the record that there were any times it was called and they failed to show up. Are there any?
we don't, okay. Well, they weren't called when my client slipped and fell. They weren't called when.
Well, but that's
Ms.
not their
Schaffner-
fault. That's the fault of, if it's anyone, if that's the fault of anybody, it's the fault of TC Colorado, not their fault. They can't know somehow that somebody fell if nobody notifies them.
Well, there's a gap also in the call analysis between August 15th and October 9th, which is really inexplicable if they have an obligation to maintain their machines in a good
They
operating
have the
condition.
obligation to maintain the machines if, in fact, they are called and notified that there's an issue with the operation of the machines. But
Well-
you have time on rebuttal.
Thank you.
Good afternoon, Your Honors. And may it please the court, my name is Jerry Christophoratos. I represent the respondent appellant Hercules Corporation in this matter. I just want to bring up a point at the outset that the Espinal argument that I believe, Your Honor, you brought up was first brought up on appeal. It was not brought up in the complaint or in the bill of particulars. I'd like to jump, if I may, to the indemnity clause. The lower court erroneously denied my motion for summary judgment to dismiss the cross claims for indemnity from TC, the Colorado Corporation, the owner of the apartment complex. And first, the facts of this case don't fall under the language of the indemnity clause in the license agreement. The license agreement says that Hercules is required to indemnify the owner, the Colorado, for incidents that arise from the use of the premises, which is defined as the laundry room in this case. But it goes on to qualify that statement by saying it applies to Hercules, their employees, and Hercules invitees. Now, the word invitees, as I'm sure you all know, is kind of a legal term of art. The only person that can make an invitee out of somebody is the owner of a property, or somebody that has some kind of possessory interest in that property. My client, Hercules Corporations, is installed and operated laundry machines at this property. It had no possessory, no ownership interest in the laundry room or any other.
But there is contractual indemnification provided for, is there not, in the lease between Colorado, Dermot, and Hercules?
Yes, Your Honor, there is an
So where, in your view, does that indemnification come in?
Are you asking me for a hypothetical situation which would trigger it?
If this doesn't pretend, I'm not saying it does, but potentially, wouldn't this, you've been left that both sides' motions for summary judgment and that issue have been denied, correct?
Correct.
So it's been left as an issue of trial, who at the end is responsible for the water that may have been on the floor?
Well, there is an indemnification clause. I'll respond to the first part of your inquiry. However, it's, as I said, it specifically says the use of the premises, which is the laundry room, by Hercules, the company I represent, its employees or its invitees. The invitees of Hercules can't be a tenant at this apartment. Hercules can't invite.
So what does the use, so what does the use mean? Doesn't the use include the fact that it has its machines operating for profit in
Sure,
the lawn?
of course.
So why wouldn't that potentially, I'm not saying it does, but potentially you could be found.
I could give you a hypothetical where I believe it would apply and why it doesn't apply in this situation. If Hercules was there working on a machine and had maybe a hose running across the hallway and somebody tripped on it, that would trigger the indemnification clause because Hercules is there using the machine, servicing the machine. If it invited a subcontractor.
But if your machine leaked water on the floor, isn't there a view that you should be held to, under this contractual indemnification, to have to make good?
Under the plain language, I would say respectfully, no, because it only applies to Hercules, its employees, and its invitees, and it cannot have invitees as tenants from this apartment building because it has no possessory or ownership interest in this specific room. But as I said,
And it doesn't apply to the malfunction of its machines?
it would not apply to the malfunction of the machines unless Hercules' actions created that malfunction or somehow Hercules didn't respond
Well,
to a
that's sort of
service
like an
call, which is
Espinal.
required.
That's sort of an Espinal type of approach, but now we're talking about contractual indemnification.
Right.
I mean, if your machine leaks and you've provided for contractual indemnification, wouldn't that be Hercules' responsibility vis-a-vis Colorado and Dermot?
I would say no, because the indemnification provision is quite artfully crafted, and it specifically says that it only applies to Hercules. I know I keep harping on this, and I apologize, but it only applies to Hercules, its invitees, or its employees. And again, it can't have a tenant at this building can't be an invitee. Notwithstanding, there's been no connection between this puddle of water that was on a linoleum tile floor, about a foot away from the washing machine. There's been no connection to a washing machine actually being defective. It's all speculation. There's been no connection between those two occurrences. So I would say it does not apply here. Also, the owner is purporting to get indemnification for his own negligence, which is not allowed without a savings clause, and it's prohibited by general obligations law. There's no savings language here.
Thank
I see
you.
that my time is up. Thank you, Your Honors.
Good afternoon. May it please the court. Nicholas Napoli, Wilson, Elser, Moskowitz, Edelman, and Dicker for the respondent appellants, Colorado and Dermot Management.
But picking up on where your colleague left off, why should you potentially be able to receive contractual indemnification if their indemnification is limited to their invitees or employees, or how do you get contractual indemnification out of this?
Certainly. So Section 17 of the license agreement provides for the scope of the indemnity. And the indemnity would be triggered under three circumstances that are laid out. The first is the most broad, which is, as counsel had alluded to, it includes the invitee language, and it's the use of the laundry room by the Hercules, its employees, or its invitees. Now, the interpretation of the term invitees is understandably, given its position, extremely narrow by counsel. And frankly, it does not logically track when you understand what this agreement is all about. These are laundry...
There would not, so there really wouldn't be any people in that category.
That's exactly right. If the term invitees within the scope and context of this agreement did not apply to the tenants of this building, it would have almost no utility whatsoever. The term invitee, these are machines that are owned, installed, and exclusively maintained, and that's the language of the agreement, by Hercules.
But it is also a stretch to say that you use the term invitees to refer to tenants of this building who are using the laundry room.
If I may, I'll provide an example. I think it begs the question, right? Why was the provision not just written to say the use of the laundry room? And I think that, and certainly I'm reading into the intent of the drafters of this contract, but I think it makes sense when you look at it this way. Hercules should not have to indemnify my clients for the use of the laundry room if the people were in there doing something completely unrelated to doing laundry, right? Which wouldn't, is possible. It certainly wouldn't be intended. That would be the carve out why that invitee language was put in there. So if it was somebody who was not there for the purpose of using machines that were owned by Hercules, installed and maintained by Hercules, and which drew revenue, they had to pay to use these machines, and that revenue went directly to Hercules. Then if somehow there was an incident that occurred just within that space, but having nothing to do with the scope of Hercules machinery there or the terms of the contract, then that would not apply.
How does the term invitees get us to that conclusion, though?
Well, there's, like I said, there's a very technical, historical discussion in counsel's brief about the term invitee. And while what I would posit is that it has as much to do with ownership of land as it does to possession of land. And when you look at it in that sense, this room was filled with machines owned by Hercules. And that's perhaps why the term invitee was used.
Your claim is that you're entitled to contractual indemnification because the term invitees contemplated tenants of the building.
Well, to be fair, I think that given that the trial court found that there was a lack of a definitive determination as to how this water got there, and certainly there was a lot of testimony and evidence introduced having to do with...
But before we get to that, how the water got there, we've got to get to what the contract says. So, but at the end, what you're saying is that Colorado and Dermot get contractual indemnification from Hercules because this contractual indemnification provision used the word invitees.
I think that based
on... And invitees contemplated tenants.
That's correct. And I think that the two theories, and this is why I was kind of getting into what the ideas of how this water got to be there was really two theories put forth. Either these were leaks that were occurring from the machine, or there was testimony that possibly it could be users of the machines transferring their wet laundry could leak onto the floor. Given that there's a lack of determination there, I'm not suggesting that if circumstances existed, now I would argue both of those situations would constitute use of the premises, use of the laundry room for that purpose. However, if there were a scenario whereby it was something that didn't contemplate use and there were negligence on the part of my client, as counsel said, sure, then that would not trigger the indemnity. But at most, I think that, or I would ask that the court...
I know your time is up, but I mean, just in terms of plain English, if when you said invitees you meant tenants, why wouldn't you have put in tenants?
Possibly because we'd be here then debating what the term tenants are. It's perhaps
a lot less than when you use the word invitees.
I wouldn't disagree, Your Honor. I think that, again, though, when you look at if perhaps there wasn't the understanding or the implication of that term, however, it renders the agreement almost nonsensical if it were to be applied in the sense of an invitee, because despite the hypothetical that counsel came up with about inviting subcontractors, that would not fit within his own definition of an invitee. So yeah, thank you.
I want to address thank you. The first time on appeal issue, if it's determinative, the case law is clear. If the issue is determinative, and it is here, the Espinal issue, and if it's presented in the lower court, as it was here, then the court can address it on the first time on appeal.
You agree that you didn't raise it at the trial court level?
I did not. I personally did not on my
I don't
end.
mean you personally, I meant
The
client's
plaintiff did
attorneys
not.
did not raise the Espinal issue in the trial court, correct?
The plaintiff did not.
Okay.
The connection to the washing machine couldn't be, to the washing machines couldn't be more clear. He indicated, counsel for Hercules, that there was a question about the connection of the water to the washing machines, that it was a certain distance away. The photographs and the drawings on the photographs indicate that the water was contiguous with the machines. There's water, there's a watermark that the handyman testified was present on machine number 15, which was very close to where my client slipped and fell.
Your client testified that when she came down to the laundry room in the first time and when she went down the second time, she didn't see any water anywhere, right?
She didn't, but she was there very briefly, and she was just doing her
And there's no other
business.
testimony that there was water in the room on that day before she fell, right?
There is no other testimony. No, there's not. But we're arguing there's a continuous, ongoing condition, and lo and behold, it appeared on that day after she put in her clothes in the dryer. So, it's not her responsibility to check the washing machines for leaks or anything like that. Ray Abinator, the porter and concierge, testified that or he didn't testify, he stated to 5 witnesses that the machines leaked on a regular and routine basis. So that certainly puts the machines, the water, that connects the water to the machines. There's certainly a nexus through him.
Thank you. Your time is up.
All right, thank you.
Hello again, Your Honors. There's just a few things I wanted to address, and I'll be as brief as possible. I believe, with all due respect, my adversary on the defendant's side is asking this court to do some legal contortions to fit the plaintiff into the definition of an invitee. I think Black's Law Dictionary and the history of the word invitee has always been connected to somebody with a possessory interest in the land. At best, we have an ambiguity here, and ambiguities should be resolved against the person seeking indemnity, in this case, the Colorado company. I'd like to turn now to the statement plaintiff made about the water on the floor. You can look at the photos. There's no water emanating from the bottom of the washing machines or any evidence of water on the concrete pad that the washing machines sat on. And I also want to discuss my adversary on the defense side's, he mentioned something about a monetary benefit, and yeah, Hercules Corporation was, of course, receiving a monetary benefit, but that doesn't somehow establish a duty towards the plaintiff, and it absolutely doesn't trigger any part of the indemnification clause. And with that said, I'll rest on my brief.
Thank you.
Unless the court has any questions.
Thank you. Briefly, I believe the duty owed to plaintiff by Hercules is a byproduct of the fact that there's substantiated allegations that a machine owned, operated, installed, and maintained exclusively by Hercules was the source of the condition that upon which she slipped and fell.
I think that's the point. We don't know.
Well, that the trial court made that determination, that it was undetermined what the cause of the water on the floor was. And certainly I would not suggest that the financial payment by use of the machines that was brought up strictly to shed some light and serve as evidence as to how to interpret this term invitee within the context of the agreement.
Thank you.
Thank you.
Macaroni v. NY Convention Center. You're very hungry. Macaroni. Yeah. Oh, you. I know. That's what you were saying. I said macaroni.
May it please the court, Nicholas Calabria with Omni Demirs McManus for the respondent, ATEC Electric Enterprises, Inc. Turner has appealed, not shown up for argument, a grant of summary judgment to ATEC dismissing Turner's contractual indemnification
I
claim.
have a very simple question. As I understand it, the judge stated the basis for his ruling in the on the record, and that transcript wasn't provided to us. How can we decide this?
I agree 100%. That's why on page 14 of my brief, I requested that the appeal be denied and dismissed. The decision is only 7 lines long, yet 3 times in that decision, the judge referred to the record on appeal, statements made on the record on appeal, causes of action withdrawn on the record on appeal, yet it was not included in the record on appeal by Turner, and therefore I believe the case law is fairly clear in this court. I cited it on page 14 of my brief. Barsoom versus Stellar Management and Ho versus Star Contractors. When the decision references the record on appeal, it should be in the record on appeal, and if it's not, the appeal should be denied and dismissed. And second of all, the contract between my client, ATEC, and Siemens did not require ATEC to indemnify Turner, and therefore the court was correct in dismissing that claim.
Thank you.
No further questions. I'll rest of my brief. Thank you.
Good afternoon, Your Honors.
Do you agree?
Excuse me, ma'am?
Do you agree?
I agree with them, but there's a couple of other things I'm saying. There are some contractual language, as for Siemens, because I represent Respondent Siemens Industry, Inc. The contract between Siemens and Turner didn't require Siemens to name Turner as an indemnity under the contract. So even though they didn't include the record on appeal on that issue, the court could rule that Siemens does not have to contractually indemnify Turner in this matter. In addition to that, as to the breach of contract for failure to procure insurance, Siemens, again, the court has the record. There's nothing in there saying that Siemens breaches contract. Siemens provided Turner produced the contract in the record, and the record specifically shows that Siemens did procure insurance on behalf of Turner in this matter. And that's it.
Thank you.
Thank you.
Beast Investments v. Celebrity Virtual. This matter, Justice Gesmer is recused. The rules of the court is that if, in fact, there is a tie, another judge will be vouched in. Don't touch the court here. Yes, please proceed.
Good afternoon, and may it please the court. Beatrice Franklin from Sussman Godfrey on behalf of the appellants, Virtual Dining. Did Mr. Beast act with malice or use improper means when he actively and repeatedly drove customers away from the Mr. Beast burger business? That's a quintessential question of fact that can't be resolved.
What
on
about
the
whether, in fact, the claim is duplicative of the breach of contract claim?
So we don't think it is for a variety of reasons, but first I want to flag that that wasn't a basis for Justice Schechter's ruling below. The critical question is whether the plaintiff is seeking the same kind of damages from the same kind of conduct on both the contract and the tort claims, and we're not here.
Well, the conduct is the same, right? At the underpinning of all of this is what you just started with, him basically saying disparaging comments about Mr. Beast's burger.
The conduct is not, it's not totally coextensive, but again, even if it was, if the harm is directed at different parties, you can still recover because the damages aren't duplicative. So here, the additional conduct is, for example, locking Virtual Dining's agents out of their social media accounts. And there's no dispute that Mr. Beast did that. And
Right,
there's
but
no
that's a
dispute
part of the breach of contract claim. That's one of the, I guess, claims made under the breach of contract claim as well, right?
that is not that's not a direct breach of the party's contract. I mean, I guess you could argue that it's a breach of the intellectual property provision, but what that goes to show is it goes to show that Mr. Beast was cutting off the critical marketing channel for the brand. And in turn, that was conduct that was directed at not just Mr. Beast Burger's customers, but Virtual Dining's market partners. And those are the damages that we're seeking on the tortious interference claims. The damage to Virtual Dining's reputation in the market, the damage to virtual dining's relationships with its market partner restaurants. And I'll note that in the trial court below, Mr. Beast has repeatedly argued that we can't recover those damages on our contract claims because, for example, harm to virtual dining's other celebrity dining lines wasn't within the contemplation of the parties to just the Mr. Beast Burger venture. Setting aside whether we agree with that position, that is the position that we've taken. So they can't now argue on appeal that we can't recover from virtual dining's loss of its market partner relationships for its other brands, for additional Mr. Beast Burger endeavors that were going to be set out. We use the example in the complaint of the on-menu items at Red Robin, for example. And so the tort and contract claims very clearly are not duplicative because they seek those different kinds of damages.
Well, a part of the contract that you entered into was for endorsements, right?
That's
it's
correct,
an
Your
endorsement agreement.
That's
and
correct.
a part of the way in which you got those endorsements was through social media posts and such, right? And being locked out of the social media account prevented basically moving forward with the duties under the contract.
But again, it also drove, thinking about the tweets themselves, which again are not the only basis for the conduct at issue here, but let's look at just the tweets because that's what Mr. Beast points to as being the duplicative conduct. The tweets themselves were not just directed at failing to endorse Mr. Beast Burger. They were directed at harming virtual dining's reputation, disparaging the quality of their restaurants.
But the disparaging portion of it is what you're arguing is also a breach of the contract because the contract included a no disparagement claim, right?
But the distinction is in what harm is being caused. So the harm for the breach of the contract, as Mr. Beast has argued we can only seek in the trial court, is the harm to the Mr. Beast Burger brand. The parties have submitted expert reports for the hundreds of millions of dollars in damages that were caused by that harm. But what virtual dining seeks to recover on its tortious interference claims are harms that go beyond that, harms to virtual dining's relationship with its market partner restaurants that carried other celebrity virtual dining brands that were planning to roll out additional Mr. Beast Burger opportunities, such as the on-menu
So
items
where
at
is
Red
there on the
Robin.
record that there was any such harm?
In several places, Your Honor. Let me pull up the exact record sites if you bear with me one moment. So I believe, for example, at paragraph 81, which is at 161 of the record, we allege that Donaldson's, that's Mr. Beast, his baseless and unlawful disparagement had the intended effect. Mr. Beast Burger's reputation was materially damaged, if not destroyed. Customers abandoned the
No,
brand.
I'm talking about
and-
virtual dining, the tortious interference.
Right, and virtual dining's hard-won relationships with vendors, partners, and suppliers were shattered, causing damages to virtual dining. Then if you turn to 156, which is at 177, paragraph 156, which is at 177 of the record, we allege that Mr. Donaldson was aware of these many other relationships with market partners that went beyond Mr. Beast Burger, and that the tortious conduct was directed at those market partners as well. For example, Mr. Beast saying, "I'm walking away from Mr. Beast Burger," that is a statement that directly caused market partners to withdraw from their relationship with virtual dining, because if they thought that they weren't going to have customers coming to their restaurant, they weren't going to carry not only the Mr. Beast Burger products, but also products
Isn't
from
that speculative? And also, these are virtual restaurants.
virtual restaurants that are delivered, that they're cooked and delivered through brick and mortar restaurants. So for example, you got
Ghost kitchens or whatever. Yes.
actually, so my client will want me to clarify.
But again, isn't that speculative that because he makes this statement that these individuals are going to walk away from your client?
It's very much not speculative, Your Honor. We allege in the complaint that these customers did walk away, that sales dropped by, I believe, 50%. But even if there is an argument,
What breach did you allege happened with regard to the social media company? What actual breach?
we allege that because virtual dining couldn't access the social media accounts to post the content that their social media manager developed, their social media manager could not comply with their contractual obligation to promote Mr. Beast Burger. And I will note that the complaint says that virtual dining was locked out. Discovery, I've learned that Social Supply actually did also, they should have been able to access the account directly, so they were also locked out directly from the, and again, there's no—
You have time on rebuttal.
Thank you, Your Honor.
May it please the court, Ben Snyder for respondents, Jimmy Donaldson and Beast Investments. Your Honor, to your question about the duplication, the allegations about social supply appear in paragraph 127 of the counterclaims, which is the paragraph about the breach of the endorsement agreement. They allege that locking social supply out of the social media accounts breached their ESA. So that part of their claim is completely duplicative of the breach of contract claim as well. I think the only other thing that they have alleged in terms of a difference between the tortious interference claims and the breach of contract claims is this idea that they are pursuing different damages. I want to step back and sort of think about the reason courts have adopted this anti-duplication rule. The reason for adopting the anti-duplication rule is that courts have a whole body of doctrines about contract claims. And they say that when you are suing on the breach of a contractual duty, there are certain limits about how far you can go in recovering damages on that breach. And to allow a plaintiff to then say, well, in that case, I want to sue in tort based on this violation of a contractual duty, would just do an end run about around those very deliberate limits on contractual damages. If my friend were right that just saying tort damages are broader than contract damages, all of the cases that we point to that apply this anti-duplication rule would come out differently, because plaintiffs would just say, well, in that case, I'd like additional damages on my tort. In that case, I would like punitive damages on my tort. So they don't point to any cases that show that just sort of making that additional claim gets them out of this duplication problem, and it would just sort of undermine the doctrine going forward.
You also argue that your client's raising the economic interest defense, but what your client did went directly against his economic interest, did it not, in terms of the sales plummeting after allegedly disparaging virtual dining?
So it didn't. Let me answer that. There are two reasons that it didn't. The one is in the counterclaims. The other is something that we've argued separately from that. In paragraphs 73 and 77 of the counterclaims, virtual dining expressly alleges that, this is from 73, in an effort to pressure virtual dining into transferring to him part of their interests in Mr. Beatsburger, Donaldson bullied virtual dining on social media. Paragraph 77 is virtually identical to that. So their burden on the malice part of the economic interest doctrine is to show that he acted solely out of malice. But in two different paragraphs in the counterclaims, they specifically allege that he acted, at least in part, to improve his bargaining position vis-a-vis virtual dining and to try to obtain an additional share in Mr. Beatsburger. Now, that's their counterclaims. They accuse Justice Schechter of sort of adopting our version. That's straight out of their counterclaims. So that's my first reason. My second reason is that the parties acknowledged at the beginning of this relationship that there was a possibility that if Mr. Beatsburger was serving raw food to Mr. Beast's followers, that could tarnish his reputation, and it might be a reason that he would not want to go forward with that. And lo and behold, that happened. So it was very much in his interest, and the parties had contemplated that it would be in his interest to be candid and authentic with his fans and say, yes, this is a problem. I'm disappointed that this is happening. And that's exactly what he did. That served his broader interests in the Mr. Beast brand, which go well beyond just the Mr. Beatsburger venture.
So this minor losing of some money as it relates to Mr. Beatsburger was nothing in comparison to what this could do to his brand as in a larger scale.
That's exactly right, and that's why that tarnishment provision was there. The parties would not have included that tarnishment provision if they thought that it was going to be in his interest to continue pursuing and promoting Mr. Beatsburger until the end of the ages, no matter what problems Mr. Beatsburger
I thought he had moved on from burgers to chocolates.
He did. I don't think this is what your question is getting at. But I wanted to point out that one of the claims they make in the wrongful means part of their argument is that he said he was moving on from Mr. Beatsburger.
Yes.
They say that that was a lie. At page 12 of their brief on appeal, they say that he ceased performing all of his endorsement services under the contract. I genuinely don't understand how they can both be saying that it was a lie to say he was moving on from Mr. Beatsburger and at the same time to say that he ceased performing all of his services under the contract.
Well, I think what was underpinning that was the fact that he was not moving on, but he was trying to get the business to control it himself. Like, that's what their argument is. He was trying to bully them into turning over more control versus actually moving on.
So I guess I'm not sure exactly what they're saying. I mean, I think
Well, I guess they'll tell us, right?
I'm confident they will. The thing I would say that is sort of looming in the background here is that if they are going to try to impose damages on my client for his speech, there's also a First Amendment problem in the background. And to the extent that they are relying on tortious interference claims and saying that those tortious interference claims go even one step beyond what the contract required, that creates real First Amendment problems. And you get into a situation where a sort of ambiguous, innocuous statement like, I'm moving on, that we don't
Well, that's
necessarily
not
know.
all he said.
Right, he said that they were,
The tweets were a bit
right,
more.
offering low-quality products and services. Right?
Yes, no.
And he was so disappointed he wanted nothing to do with them.
Exactly.
So he said those things. That part of their complaint, I think, or their counterclaims, the problem there is the duplication problem, and then also just the fact that they haven't shown that he acted solely out of malice.
Are there any allegations that Social Supply Company breached its agreement with CVD to supply marketing services?
So I don't understand how that breach happened either. I think it would be a very strange contract if somehow Social Supply were in breach because someone else changed the passwords on social media accounts and it had nothing to do with it. Now, Virtual Dining, of course, has that contract. They could have come forward and they could have pointed to the provision of the contract that makes out that very counterintuitive duty, but they haven't. They didn't do that below. They still haven't done that on appeal.
Thank you.
I'll start with the claims about Mr. Donaldson's alleged economic self-interest. Mr. Donaldson had so little faith in his claim that the quality control issues were harming his brand that he actually tried to withdraw that claim in the trial court because he didn't want to have to produce discovery related to the incredible success of his brand in the last few years, much of which was due to Mr. Beast Burger. The parties have recently submitted competing expert reports on exactly these issues of whether Mr. Beast Burger, in fact, was terrific for Mr. Donaldson's brand. As the court may know, Mr. Donaldson was on the cover of Time magazine, and that article prominently featured Mr. Beast Burger. So it's a little bit hard to swallow that Mr. Beast Burger was terrible for his brand. Excuse me?
Hard to swallow, excuse the pun.
Yes, pun not intended, but very much appreciated. But in any event, what this goes to is this is a question of fact. It's a question of fact whether he acted with malice. Even if we haven't shown that he acted solely with malice, we have also shown that he acted with improper means. That brings this case squarely in line with EPAC, where this court found that.
What was the breach with respect to Social Supply? I don't think that we ever got an answer to that question.
So the breach is that they had an arrangement with our client to provide social media content. They were unable to satisfy those obligations because they were locked out of the account. But even if the court doesn't find that that was an independent breach of contract, that lockout demonstrates the improper means that Mr. Donaldson used to try and kill not only the Mr. Beast Burger business, but also to harm our client's relationship with its other vendors and market partners. And except for the duplication argument, I've already explained why virtual dining's relationships with restaurants that carry other virtual dining brands, the NASCAR brand, the MLB brand, the Pardon My Cheesesteak brand, those aren't duplicative of our breach of contract claims. And Mr. Donaldson has repeatedly argued below that they aren't.
Thank you very much. Thank you both. Stabile versus Jagenati brothers. Yeah, I was thinking. I have the same thing. Yes.
Good afternoon, Your Honors, and may it please the Court. Daniel Smith from the law firm of Adam C. Weiss, PLLC, for the appellants. This appeal turns on whether the complaint alleges any facts specific enough to support a cause of action for unpaid overtime and prevailing wages. It does not. The pleading identifies no specific projects the plaintiffs worked on, no specific pay periods, no specific underpayments, and under New York law, even under liberal pleading standards, this claim cannot survive. In Mendoza v. Cornell University, a case decided by this court in 2023, the court dismissed an overtime claim despite allegations that the plaintiff worked 39 to 40 hours weekly, took on extra shifts that resulted in unpaid overtime, and worked 6 shifts in a week during one specific week in June of 2018. This court held that even those specifics failed to support a reasonable inference of a wage violation. Here, plaintiff alleges far less. There are no allegations of any specific weeks worked in excess of 40 hours. There's no allegations of numbers of hours worked at all. There are no specific pay periods referenced. The pleading, respectfully, is entirely conclusory and fails. Now, appellants note that plaintiff now seeks to withdraw the second cause of action based on unpaid overtime, and we submit that that concession is
Was
warranted.
the plaintiff required to identify specific dates of employment?
Well, more specific than just saying various projects throughout, and not identifying which projects that the named plaintiff alone worked on. We're not asking for class-wide identification of which projects each potential plaintiff worked on, but at least for the named plaintiff, there's not even a single specific project alleged that the named plaintiff worked on. Now, turning to the cause of action for the prevailing wage claim, this cause of action suffers from the same defects. The plaintiff does not allege, again, what projects he worked on, what wages applied, what he was paid, when he worked exactly, or how he was underpaid. Now, in their brief, respondents rely on Dabrowski v. ABAX Inc., decided by the First Department in 2009. In that case, this court allowed a prevailing wage claim to proceed only because the plaintiffs identified specific contracts to which prevailing wages applied and referenced the entries in the city's Vendex database. And even then, the pleading was barely sufficient. Here, the plaintiff does not identify a single contract, does not identify a single project name, does not identify a single job location, rate, or date. And as we expressed in our reply brief, even under Dabrowski's 2009 standard, which predates Mendoza, the complaint's lack of any factual anchor fails to afford appellants the notice required to defend the claim. Significantly, Mendoza represents this court's more recent guidance on the wage claim pleading, issued 14 years after Dabrowski. This recency suggests that the court is upholding a refined.
So in Mendoza, the claim for non-payment of overtime, which you had just discussed, there was no allegation that the plaintiff had worked more than 40 hours a week, right? Here, the plaintiff is alleging entitlement to overtime, but you didn't put in anything that I saw to dispute that, to state that the plaintiff did not, in fact, work overtime, right?
Not that they did not, in fact, work overtime, that the pleading was, more so that the pleading is facially deficient in the allegations.
Right.
And not specific enough.
But was there anything to state that the plaintiff did not work overtime?
We didn't contest any factual basis, just the pleading itself. If that makes sense.
Okay.
Okay. I waive the rest of my time on this, and if I have anything on rebuttal, I'll share.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. James Emmett Murphy for plaintiffs' respondents. I would never.
That's the issue raised by counsel?
Absolutely. I would never, under any circumstances, throw any of my partners or associates under the bus under any circumstances. I stand here responsible for everything that my firm does. Had I been the one to draft the complaint, I would have inserted that the prevailing wages that were required to be paid were those that were required under Labor Law Section 220. Solely because this court in Toktaman versus Human Care found an identical pleading that stated that the wages that were required were those under contracts which had Public Health Law Section 3614C requirements for the Wage Parity Act, that citing that statute and saying that the contracts that called for the payments under that statute was sufficient to state a cause of action. Similarly, in Ross versus No Parking, this court found a similar complaint sufficient, where that said that the prevailing wages that were required to be paid were those called for under Section 19-142 of the Administrative Code. I would have put Section 220 of the Labor Law is the provision that requires payment of prevailing wages in the complaint had I been the one to draft it, and that's why we made a request before the motion court and here to have the opportunity to replead if anything is found to be insufficient in the complaint. All that being said, the specifics of the plaintiff's claims and the putative class's claims come forward in the documentary evidence that was submitted by the defendants. Defendants say that during his last week of work, the named plaintiff worked on a project for tree pruning in Queens that was led by the New York City Department of Parks and Recreation. They provided pay stubs for the work that he performed there, showing that he was paid $43.75 an hour, which is less than the prevailing wage rate for that work. We have alleged all of these contracts that they entered into with the City of New York, Parks Department, and other agencies, which I listed a bunch of those in footnotes in the motion court below, which is on record at page 558 and also here, that all of those contracts required payments of prevailing wages at a higher rate than the workers were paid for. They produced documents saying we paid prevailing wages for jobs in Yonkers, which is great. We didn't sue on any jobs in Yonkers. We're only suing on the jobs that the plaintiff performed and other members of the putative class performed work on in New York City. The exact thing that we're suing for is shown in the documents that the defendant submitted on this motion. And so we have, to the extent that there are any deficiencies in the complaint, they're made up for by the fact that everything was explained by the documents the defendants provided, and we cited all of those in our motion. Just one point that I do need to make clear is that over and over and over again in their motion papers and in the papers before this court, they have cited to federal pleading standards under Twombly and Iqbal. Those do not apply in New York state courts. The pleading standards set forth in Leon versus Martinez by the Court of Appeals 30 years ago and repeatedly upheld since then that as long as the claims give notice to the defendants of the transactions at issue, that the court grants every favorable inference in favor of the plaintiffs and sees whether the facts alleged fit within any possible cause of action, is fundamentally incompatible with the requirements of Twombly and Iqbal. And the defendants repeatedly, over and over again, try to bring that federal pleading standard into the New York court system. And that really has no place here. Court of Appeals has made that clear over and over again. This court has made that clear over and over again. And the pleading standards set forth by Ross versus No Parking last year, and Tuck Common versus Human Care in, I believe that was 2019, we would have fully satisfied those if we had just said the prevailing wage is required under Labor Law 220.
Thank you.
Thank you.
Just briefly, Your Honors, I would like to address counsel's reference to our acknowledgement of federal pleading standards. This is not a misrepresentation of the pleading standards. As we explained in our lower court reply to this contention, this position has reflected an evolving judicial trend in New York courts. Multiple New York courts, which we've cited in our brief, have invoked Twombly and Iqbal, including Kazani v. City of Suffolk, which applied Iqbal to assess a complaint, Powell v. City of New York in the Bronx, dismissing a Section 1983 claim under Twombly and Iqbal, Cabrera v. City of New York out of the Bronx, and others. And this trend has been aptly summarized by the court in Credit Acceptance v. Pickney out of New York City Court in 2023, stating eloquently, while neither the New York Court of Appeals nor the Appellate Division have expressly adopted the heightened pleading standards set forth in Twombly and Iqbal as applicable to cases arising in New York courts, a shrouded pattern is emerging in some New York trial courts that appears to do just that. We note this context to affirm that our motion court argument was grounded in observable judicial practice. Thank you.
Thank you.
James, it was a pleasure.
Thank you.